Court officer. Court officer.
Sir, ಹೇಳಿ.
There is no session.
Sir.
In a late.
End date.
I am not able to.
ಹೇಳಿ sir, ಏನ್ ಬೇಕು ಹೇಳಿ.
Let's. My serial number is 20. What is that?
Sir, ಇನ್ನು ಕೋರ್ಟ್ ರೆಸ್ಯೂಮ್ ಆಗಿಲ್ಲ ಇದೆ.
Oh, sorry.
ಬಂದ ಅಲ್ಲ ಚೇಂಬರ್ ಅಲ್ಲಿ ಫೋನ್ ಮಾಡಿದ್ರಾ?
ಇಲ್ಲ, ಮಾಮೂಲಿ ನನಗೆ ನಿಮ್ದು 10:30 ಅಂತ ಹೇಳಿದ್ರು. ಆಮೇಲೆ ಮೇಡಮ್ ಬೇಕಾಗ್ತದೆ 5 ನಿಮಿಷ ಬೇಗ ಹೋಗ್ಬೋದು.
ಹೌದು,
ನಾನು ಚೇಂಬರ್ ಕಡೆ ಹೋಗಲ್ಲ, ಹಿಂಗೆ ಬರ್ತೀನಿ.
ಇವಾಗ ಪೋಸ್ಟಲ್ಲಿ ಹಾಕಲ್ಲದೆ ಇದ್ದಿತ್ತು. ಏನು
ಇನ್ನೊಂದೆಲ್ಲ ಬೇರೆ
My lords, I am the petitioner husband. My application to summon a doctor has been dismissed. My petition is for granting divorce on cruelty. It may be taken up end of the list because it is posted for arguments on day after tomorrow, my lords.
When is it passed?
On 4th, on 22nd it was passed. On 4th we have filed, my lords. On 10th it is posted for further arguments. And only 2 days the time is given, and a lot of holidays were there in between also. Hence we could not get the certified copies.
Tomorrow, not today. Yes.
Yes, my lords. Maybe tomorrow, my lords.
If the office objections are complied.
It's complied, my lord. So end of the list. If it is end of the list, if it is taken.
Objections are complied, list tomorrow. Yes.
Yes.
Out of the list.
Obliged.
Last occasion, my lord ordered the LCR to return to tribunal, my lord, to enable the withdrawal of the amount, my lord, claimant. But by oversight, some RPFC was connected with this matter, my lord. That is nothing to do with this matter. Request for tomorrow to now.
Yes. For the list.
Bloods. On 10/6, this honorable court had ordered the parties to give the documents with regard to where the mother and the child were staying. The documents are before this honorable court. This matter may kindly be heard and
What is that?
5493, please, my lords. For the wife, on 10/6/2025, this honorable court had passed an order that both the husband and the wife will submit a set of documents to prove where the wife and the child were staying from 2017 onwards. Both of us have submitted the documents, my lords. The documents need to be heard upon.
Is it the matter where this court has said not before?
No, my lords, nothing like that. If that is the opinion, my lords, then the court may pass the speaking order.
Yes. Take it. Yes. For the list.
Page-wise adjournments, list 1, page number 2, serial number 56, page number 3, 7, 8, page number 4, serial number 10, 11, page number 5, serial number 12 to 16, page number 6, 17 to 20, page number 7, 21, 22, page number 8, serial number 23, list number 2, page number 2, serial number 5 to 10.
Serial number 6, my lords. I pray for a short accommodation. I'm appearing for the respondent.
It can be adjourned. At the request of learned counsel for the respondent, list this matter. Give a date looking at the.
17.
Yes.
Grateful.
Page
Look
number,
at it. Intermodal is their extent.
page number 3, serial number 11 to 16, list number
Lordship, serial number 15, I appear for petitioner. I am informed to the other side. I have some inconvenience, your Lordship. Lordship may grant a week's time.
Yeah, the request of learned counsel petitioner.
19.
Yes, 19.
Grateful.
List number 3, page number 1, serial number 2, page number 2, serial number 3 to 6,
My lord, serial number 4, my lord.
page number 3,
In
serial
which
number
case?
7 to 14,
List number 3, serial number 12, may kindly be taken up next Monday. Not well.
Serial number 14, my lord.
No. This list number 3, serial number?
sorry, Ranjit Gotur.
You appear for whom?
And for the respondent, I have informed.
Yes, this give in the month of October.
My lords, I am appearing for the petitioner in this matter, my lords, the proxy counsel, my lords. My lords, I have not informed the counsel on record, my lords. It may be taken up, my lords. It may be called for, my lords.
Colleague, let it be short accommodation, and that is on Monday. They have filed about 3 or 4
My lords,
cases.
let the matter reach, my lords. It's
Having
normal.
taken this day, he is not paying. He has filed so
Then it's
many
better that if the matter is heard today.
Madam, I am not well.
Yes,
I have
my
to
lords.
go for medical procedure in the
Yes, list this matter.
on Monday.
Yes.
Monday.
Monday not possible. There are so many matters.
My lords, I request the matter to be called
It
out, my
can't be
lords.
taken. Both your requests can't be considered.
22,
My
9.
lord, serial number 14, my lord.
Look at it. If intermodal is their extent. Yes.
Serial number 14.
14.
14, my lord. 4 weeks time.
Huh?
4 weeks. Serial number 14, my lord. List number 3, serial number 14.
14, I appear for appellant in one matter.
One time.
List number 3, sir.
ಆಗೋಯ್ತು. ನನ್ಗೆ
Have
ಎಲ್ಲಿ
you
ವಿಡಿಯೋ
posted
ಮಾಡೋ
number
ಅಂತ ಹೇಳ್ತಾರೆ ಅನ್ಕೊಂಡೆ ಯಾಕಂದ್ರೆ
Yeah, have you informed the other side?
Number 1.
Inform the respondent.
Respondent to some.
Please wait till the matter is called. Yes, next.
Serial number 4, my lord. Serial number 4.
11.
My lord, serial number 4.
Page
Yes.
number,
RPFC 141.
page
I
number
pray
4.
for a week's time, not 12.
I oppose my lord. Last week, my lord, the.
All right. If he opposes, I do not want to.
Yes, next.
My lord, serial number 4, my lord. Serial number 4.
Conditional order is passed by this court.
I'll be here at 2:30.
Serial number 4, my lord.
Page
I
number
ne-
4.
Serial number 4 of which list?
Right, in the
He is
serial,
also serial number 4.
because I am in serial, the list number 3, serial number 4, my lord.
He is also mentioning that.
No. It's not 14, my lord. His number is 14. My serial number is 4.
14 is already over. You said serial number?
11.
Oh, yes, serial number 11.
11.
11.
When I oppose my lord. Last
I
week,
am
my
not
lord.
granting, Mr.
My lord,
The little,
Court it is matter is listed, my lord. It's short.
you at least understand what the court is saying. I said I'm not adjourning it. You can come when the matter is called.
I'll be here
Yes,
at.
Serial number 4, my lord. Serial number 4.
Leave.
yes,
I'll be here at 2:30.
yes, Mr. Yes.
Page number
My
4.
lord, serial number 4, my lord. I need 2 weeks time for it.
Why?
Because hard. Serial number 3. List number 3, serial number 4. my lord.
Why you want 2 weeks' time?
So because he's not feeling well, he's a
Who?
senior, my senior, my lord.
When
Petitioner.
DCM.
What about respondent?
Respondent, we don't know.
When respondent comes in his presence, you ask for time, not now. Yes, next.
Page number 4, serial number 15 to 21.
Serial number 15, Lord, I am for petitioner. I inform the event council appearing for the respondent next week. Lord, today I am not.
Yes, October. Give a date in October. Yes,
Date may be given, but because.
October, they'll give the date
I'll give.
basing on the list. Yes,
Page number 5.
take that. A memo is filed stating that the matrimonial dispute between the parties has been amicably settled. Hence, they want to withdraw the petition. Memo is taken on record. Dismissed as withdrawn. Yes,
Page number 5. Cell number 22 to 23.
23, my lord. Kindly only time.
you appear for whom?
D. Prakash. For petitioner.
Respondent,
Balakrishna K.
informed. Please wait till the matter is called.
List number 4 for referring to Lok Adalat matters.
So in this,
Serial number 4, it is
1
on
minute,
liability.
1 minute.
1.
Delete first one. Delete a week's time. The memo for memo is filed seeking dispensation of notice to R1. May a notice is dispensed with, it can be referred. Then next two, R2 for the first time. R2 is who? Look at it.
R2. Number 2. R2. Insurance company.
We'll appoint somebody and then refer the matter to the Lok Adalat.
May I make a mention, my lord?
Yes,
List number 1, serial number 14, my lord.
And for the enhancement, my lord, in this case.
we will, please wait, I'll not adjourn it.
List number 2, serial number 2 nalli.
List number 4, serial number 2. Who is respondent number 2?
It is Cholamandalam. General
Cholamandalam. You
insurance.
appear, Mr.
No.
Who appears for Cholamandalam?
Cholamandalam.
Pradeep.
Pradeep appears. Cholamandal Pradeep. Mr. Pradeep is directed to take notice
For R2.
for respondent number 2.
Refer to.
The same, refer to the Lok Adalat. 3,
Serial number 3.
who is R1?
R1.
Look at it, this is also insurance company. And the land counsel, the applicant shall serve the copy of the appeal memo on the counsel to respond. Yes, 3.
Serial number R3
Oh,
is.
probably this is the insurance company's appeal.
Yes, ma'am. Insurance company appeal.
Steps for R1, a week's time default order.
Serial number 4.
Then from 4, all the
On
matters.
liability.
Ah,
It is on liability.
4. Delete from the list.
I'm for the respondent in this, my lord.
Yes.
5.
5.
5 to 9.9.
Of all the matters refer to the local adalat from there.
13, my lordship.
Also, notice
13, my
to
lordship.
come.
2 weeks time, 2 weeks time, my lordship.
Lok adalat it will go. No 2 weeks time. Yes, all the other matters.
9.1 also notice.
My lord.
9.1.
9 must be there.
9 is there.
So BP, then Mr. Nagarjun Reddy D is directed to take notice on behalf of the respondent.
In 10.1 also, furnish R1 and R2, both
Mrs. Shivanagowda is directed to take notice in 10.1.
for insurance company.
Yes.
My lord, serial number 1.
Which
List
list?
number 1, serial number 1.
In all matters.
Huh?
List number 1, serial number.
Be called.
Okay, right.
For,
Okay, okay.
for being spoken to list number 1, cell number 1,
Ah,
not ending,
Ah.
for appellant,
appearing for the respondent number 2, that is Oriental Insurance Company. Madam, you have given judgment on 15/4/25 for 4,06,500 liability. After considering all other facts. Now, your judgment is for respondent number 2 only you have mentioned instead of respondent number 1 and 2. Because in respondent 1 also,
Number 1.
that Nagaraj. Respondent number is Surya Santosh Dattatreya Suryavamshi, lorry owner. Because of driver's negligence, rash and negligence driving, and also that appellant.
Is the order.
Yeah.
1 minute.
Modification of judgment is required.
1 minute, 1 minute.
Yeah, okay.
Where is the finding of the court
Yeah.
that the owner, there is a, come to the order, come to the award?
Yes. Award 1352 or 16 lower court has ordered for 50% of the liability.
How is it going to make difference? Please tell the court. There is
Yeah.
no pay and recover.
Ah,
There is no pay and recover.
okay.
Insurance company is liable to pay the compensation.
Madam,
Or you have insured the vehicle. So what is the difference? If I can understand, if there is any, the pay and recovery is ordered from the owner. Owner and the insurer are joint and severally liable means what? Ultimately, insurance company that's going to pay the compensation.
yeah, 50% only, madam.
Where is it? Where is
Yeah,
50%?
lower court judgment.
Let's see, come to paragraph number 13, page number 13, paragraph number 22.
Of what, madam? Here, see, 1352 or 2016 lower court judgment.
Please come to paragraph number 22 and the order.
Which one, madam? Which one, madam? 13th, madam? Which one? Lower court. Illiದೆ ನೋಡಿ madam.
trial court order 22.
Trial ಇಲ್ಲಿದೆ.
22.
22 ಅಲ್ಲ.
22 ಇದಕ್ಕೆ ಇಟ್ಟಿಲ್ಲ.
22. 22 ಇದರಲ್ಲಿ ಇಲ್ಲಲ್ಲ ಯಾವುದು ಇದು ಕೊಡಿ ಇದು ಅಂತ ತೋರಿಸಿ because both appellant
Come to the decree. Decree.
decree is for 50% of the.
That's what, please look at the decree and tell the court where it is. Read from the decree.
One lakh 78,500 they are awarded. So that is 50%. Both respondent 192 have to bear the liability.
Where is 50%?
It is there, madam. Yes, course, sir.
Look at the decree and tell the court.
Yeah.
Please look at the decree. Have you represented
Yeah.
this matter when it was, have you argued this matter?
Yeah, madam.
Have you argued when the matter, when the.
Yeah, everything is over. Everything was, even you fresh calculation also made for other expenses also. That is.
Yes, Mr. Please look at it. What did where did the award say that? Come to the judge, decree.
It is in page number 12, paragraph number 21 of the.
No, decree. That is what is the paragraph, that's what is executable.
1,78,500 is directed to pay by the second respondent.
Plus additionally you have made.
Okay. Where is the 50% that is stated in the decree? It is not stated. That's what I'm telling him.
He is referring only paragraph 21.
No, ultimately what is this? The
Award.
decree.
Award.
Where did they say in the award?
Petitioner is awarded the total compensation of rupees 1,78,500 with interest at 6%. Respondent 1 and 2 are jointly several.
That is owner and the insurer.
Second respondent shall deposit the award amount.
Second respondent is your owner, the Oriental Insurance Company. First one is lorry owner.
So what is that, Mr. Prakash? What is for being spoken to that I'm not able to understand?
No.
His submission is not, they are liable to pay only 50% of.
Yeah.
What I'm saying is the order award is silent on that. The award says the amount has to be deposited by the insurance jointly and severally. That is what in every award it will be.
For the tribunal.
Yeah.
It has to be clarified from the tribunal, not from this court. Once it is clarified from the tribunal, then this will be. Now, how can they do it now when already this matter is also disposed of?
Then they have to go for.
That you please tell him. The matter is placed before the court and the caption first being spoken to. It is stated that the insurance company is liable to pay only 50% of the compensation. This court has perused the award. Award is silent in that regard. Hence, no order can be passed. Yes. Next.
50% negligence is captured on the petitioner for contributory negligence. Therefore, it is hold good. 50%
That's why
contributory negligence.
whatever give that.
Sorry.
Lord, 3,57,000 is the award amount.
Hmm.
Insurance company is directed to pay 50% of the award amount. 50% is deducted towards contributory negligence on the part of the petitioner. Paragraph number 21. In trial court. It is proper.
So that aspect is not at all discussed. This is an appeal filed by the claimant. So why should we maintain the same order? Because there is a finding by the court.
Contributory negligence.
When the matter is listed, when the judgment is pronounced in the court, dictated in the court, simply advocates keep quiet.
Contributory negligence is, madam.
That has to be argued, is it not?
That all we have told previously.
What previously told? This is an order that is dictated in the court.
Yeah.
You are hearing, then you should tell the court.
Yes, madam.
Nothing contributory negligence, nothing is argued. Even his argument is also not there. If it is there in every case, I will record that the counsel for the insurance company argued so and so. Look at it. I can understand if it is a reserved matter. Dictation in the court.
Yeah.
Advocate he'll hear what the court is dictating.
Sunanta is Rato.
It was there. Let me see. Let me look at it. Chamber. Yes, next.
Cell number 2, Patel D. Karegowda.
For appellant.
Patel D. Karegowda.
When is the order passed by the coordinate bench?
28/7/2025.
28/7/2025.
Para number 19.
Paragraph number 19.
Typographical mistake.
7,87,800.
Where is that? Where is the order?
Paragraph number 19.
Paragraph?
19. Page 11.
Hmm.
7,87,800 is the enhancement made.
Where do you get that?
Para
Thus the
number
claimants are
19
held
second.
entitled for enhancement of
7,87,800. Is mentioned as 1,96,000.
Before trial court, it was awarded 17,71,000 was award amount before the trial court. It is enhanced from 17,71,000 to 25,58,800. Therefore, my lord, the enhanced amounts come to.
1 minute. Where is the trial court's award? Is it mentioned in this?
Please.
Which paragraph? So trial court has awarded 17,71,000.
Please, ma'am.
This court
25,58,800.
25,58,800.
By enhancement 7,87,800.
1 minute. 808 minus 17 lakh 7. Enhancement is 7,87,800.
Please.
It is mentioned 1,96,000 instead of 7,86,000.
The other two portion, my lord, there is a wrong mentioning of amount.
Paragraph number, now I see this at paragraph number 19.
19.
And
the same para 19, my lord, 1,19,596.
again, bottom, yes.
Please.
Then counsel for the petition submits, appellant submits that. There's a typographical mistake in the order dated. In the order dated 28 July 2025, where when the enhancement is 7,87,800, it is mentioned as 1 lakh rupees, 1,96,000. This court has perused the order. The enhancement is 7,87,800. In the order at page number 90, paragraph number 19, 1,96,000 shall be substituted as 7,87,800. I have underlined those two. Yes.
Page number 3 is serial number 3, KT Madhu, B Pradeep.
Paper.
You see that?
Understood.
Then counsel, the matter is placed before this court, the caption for being spoken to. This court had disposed of the matter on 11/8/2025, and the court had partly allowed the appeal, fixing the liability on the owner of the vehicle. Land counsel submits that in the latest judgment of the apex court in Sunita Devi case, decided on 8/8/2025, the Honorable Apex Court, in similar circumstances, had fastened the liability on the insurance company. This court has perused the judgment, and there is no such law laid down by the Honorable Apex Court.
Much of it.
Hence, the same memo is dismissed. Yes.
For dismissal matter, cell number 4.
Respondent claimant.
Yes.
Not that.
Yes.
One mistake committed by MACT in treating in annexure, page 21 of the judgment.
You are on,
no evidence.
On liability.
Liability.
On the ground?
No driving license, no permit, no fitness certificate.
No
Transport.
driving license, no permit.
No permit.
And
At least pay and recovery, I will have an order of pay and recovery.
owner is served in this.
My lord, owner was represented before MACT.
Notice to R3 is held sufficient.
Sufficient.
Self-sufficient through paper publication.
Paper publication. Yes. So let's see.
My lord, the
Let us see. Let us see the order.
MACT holds
Let's
that
see that particular paragraph.
liability, para 33 minutes.
Please read.
It is an admitted fact that respondent number 1 is the owner and respondent number 2 is the insurer of the offending lorry, so and so. It is also admitted fact that as on the date of accident, the policy was in force. Though the respondent number 2 contended that the driver of the offending vehicle had no valid and effective driving license and vehicle did not possess valid permit and fitness
First
certificate,
thing is to say
it has
that
not produced any document.
No. First thing is about driving license. Now the charge sheet is filed under the provisions of the Motor Vehicles Act.
3-1. As far as permit is concerned, I have led evidence also of RTO.
Driving license, I'm saying.
In fact, RTO is not examined.
Not RTO. Whether this charge sheet is filed under 180.
Melody.
Give the final report. Exhibit P9.
187.
Huh?
Charge sheet filed under section 187 of MU Act. 181 Act.
279, 337, 304 PC, read with 187 of IM.
187.
Motor Vehicles Act.
That is not charge sheet. In the charge sheet, it is not available.
Exhibit P9.
Well, my submitment, I had led evidence of my party and also RTO to substantiate that there was violation of permit conditions. No permit was available.
So,
But however, MACT also holds, Melody,
so as far as driving license is concerned, no such.
permit, in fact. My lord,
Then
para 9 of the judgment,
yes, let's
MACT
see.
holds that I have led evidence.
Let's see. Yes.
Para 9, second portion of it. The second respondent has got examined its deputy manager as RW1 and one witness RW2 and got marked documents R1 to R6.
What are they?
My lord, these are.
Let's see the evidence of RW2. RW1 and RW2. RW2 is RTO. So let's see your chief, so that we'll understand what is your case.
RTO. Deputy manager's examination RW1, my lord, may read it. My lord, I come to third para. I state that the vehicle bearing number so and so was covered. Para 4. I state that the vehicle bearing number so and so was not having a valid permit and fitness certificate as on the date of accident. The permit stands valid only.
Date of accident?
My lord, the date of accident.
Date of accident, my lord.
19/4/2017, my lord. 19/4/2007.
Then RW2,
It was RW1, RW2 is RTO. He also,
what did he say?
he would reiterate that there was no permit.
RW2 is in English, Kannada. Even his chief examination also.
From RTO also.
You have?
My lord, I don't have a copy.
Give it to me.
I read it.
Evidence.
RW2.
If you look at the documents, nothing is placed. If you look at the annexure.
In appendix, no mention. And MACT also holds at one para, as far as liability is concerned, no documentary evidence was adduced. But it also reflects in para 8 that I have led evidence.
Exhibit R1 to R6. Then at least there must be fine place in the lower court record.
RW2's evidence. ಭಾರಿ ಸರಕು ವಾಹನ KA09B ವಾಹನಕ್ಕೆ ನಮ್ಮ ಕಚೇರಿಯಿಂದ ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ಮೇರೆಗೆ ಬಿ ರಿಜಿಸ್ಟರ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಹಾಜರು ಮಾಡಿದ್ದು ಅದನ್ನು ಗುರುತಿಸುತ್ತೇನೆ. ಸಾಕ್ಷಿ ಗುರುತಿಸಿದ ಬಿ ರಿಜಿಸ್ಟರ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಎಕ್ಸಿಬಿಟ್ R6 ಎಂದು ದಿನಾಂಕ 26/4/2017 ರಂದು ವಾಹನಕ್ಕೆ ನಮ್ಮ ದಾಖಲೆ ಪ್ರಕಾರ ಅರ್ಹತಾ ಪತ್ರ ಇರುವುದಿಲ್ಲ. No ಅರ್ಹತಾ ಪತ್ರ.
Fitness.
Fitness.
Then what he says about
B register extract is produced and under which there is
with regard to permit, no evidence.
No evidence.
So when it comes to the fitness,
my lord, I have produced B register extract. PW1 has produced B register extract. This is
and
what.
Who is the competent person to adduce evidence on that regard? With regard to the permit.
This permit has to be produced by the owner. Owner did.
Who has to lead official witness?
Official witness, in fact, that
it's already there.
A public document is produced before the court.
No, he was already there. RTO is there.
Vahanada permit and fitness certificate hajar madiddu that my witness has produced those two documents. But this person who is from he's a senior motor vehicle inspector, he would say that there existed, as far as P6 is concerned, there was no fitness certificate.
If fitness certificate is a different aspect. We are only on the permit. If you say fitness certificate, is it the cause for the accident? Is another issue.
My lord, what will happen is, as per section 56 of MV Act, if a fitness certificate is not in existence, registration automatically comes to an end. When registration itself comes to an end, question of plying a vehicle on a public place would not be there. That is the reason why fitness certificate is given more importance, even by 5 judges bench of Kerala High Court also. They say that it is a fundamental breach.
What is the law on this by the Supreme Court?
May not yet to come across, but in two decisions Supreme Court has held. If fitness certificate is not there, registration would come to an end. There are two decisions with the Supreme Court on this point, but they were dealing under Consumer Protection Act. But law is clear as far as this aspect.
We cannot motor vehicle and consumer protection.
Both are same because they were interpreting provisions of Motor Vehicles Act while deciding fitness certificate.
There is no judgment right on this point.
Right on this point,
Let's see.
I will check it up.
Kerala High Court judgment. Kerala High Court judgment.
Kerala High Court 5 judges bench decision. Can I give it tomorrow, my lord? Those decisions, I will.
Yes, next.
5. Cell number 5.
Notice.
Owner appeal, my lord.
Delay.
This
2020. IA 2 of 25. to condone the delay of 1273 days.
Conditional order, my lord. Conditional order, my lord. Office
So
objection, my lord.
what were you doing for 1273 days?
Not keeping well, my lord.
Will not.
My lord, owner appeal, only ground that, my lord.
Except for the claimant, we will not show any indulgence of any nature to the owner.
In this case, my lord, owner appeal, my lord, permit is, as on the date of accident, permit is.
You may have 101 reasons on the
Permit is
merits of the
there, my
matter.
lord. Permit is there, my
When
lord.
is this appeal? Let's see. When was the order filed or order passed?
Oh, my lord.
That's on 13th February
13th February
2019.
2022.
Then you will come before this court
Yes.
filing an appeal. When? When is it numbered? In the year 2020.
25.
2020.
Yes, my lord.
And already what is the delay as on that day?
My lord, 1,273 days delay. 273 days. my lord.
1,273 days. Then that is first step one. Step two is this. No, 1,273 days is in recalling the order.
Recalling application.
I'm asking what is the original delay?
Original, my lord, I filed the appeal, my lord, 6 November 2019, my lord.
Already there another 4, 5 months, 6 months, 176 days there. So why should we set everything?
My lord, on humble submission, my lord, permit is there, my lord. Kindly maybe recall the order, my lord. I will permit is my lord.
No, I'm only asking you one question. Why should we do all this? There should be a genuine reason. You come to the court with a delay. You again, when an order was, conditional order was passed,
Yes.
you filed this application with a delay of 1,273 days.
Yes, ma'am.
Why should we put the clock back now? What are the reasons you have stated at least?
My
We'll
lord,
see.
as on the date of accident, my lord, no permit, my lord. My lord.
I said, what are the reasons for the condonation of delay?
My lord, delay, my lord.
You have to pass through the first.
Not keeping well, my lord.
I am the counsel
Instead
for
of-
the appellant.
Yes.
There is a judgment that advocate should never file an affidavit in a condoned delay petition. Whatever reasons you have to state to your client. Advocate shouldn't file affidavit. IA number 1,
kindly-
IA number 2 of 25 is filed to condone the delay of 1,273 days in filing the application to recall the order dated
10/2/2022.
on 10/2/2022. On 10/2/2022, an order was passed that the objection shall be complied with within 2 weeks, or else the appeal shall be dismissed without further reference to the court. It is submitted that the counsel was under the impression that the needful is done. And when the client inquired, then they came to know about this default order. Though this court is not convinced,
My lord, kindly maybe impose cost, my lord.
is not convinced with the reasons stated, considering the fact that the submission that there are merits in the appeal, the delay of so and so days is condoned on the condition that the petitioner, the appellant shall pay an amount of rupees 5,000 to the Advocates Association, which is the insurance company.
My lord, insurance company, my lord, United India Insurance Company. Respond number 3, my lord.
Krishnaswamy, you appear for United India? Mr. Krishnaswamy is directed to take notice on behalf of the insurance company. The counsel for the appellant shall serve the copy of the appeal memo. As far as respondent number 2 is concerned, he shall pay the process within 1 week, or else the appeal shall stand dismissed without further reference to the court. Yes, next.
Cell number 6, finalizing BC Shivanagowda for appellant.
In this case, I appear for respondent. Insurance company appeal challenging the liability,
On the ground,
implication of the insured vehicle, and the date of accident is different.
let's see the particular paragraph.
That before that minute, exhibit P R5 may be kindly be seen.
No, let's first
Please.
let me understand the facts. Yes, paragraph.
That the paragraph issue number 1. What? But in this case, Malad, the allegation of the complainant is that Malad on 8/7/2012, he has sustained injury and admitted to the hospital for 15 days. Thereafter, he filed the claim petition stating that he has met with an accident. He has met with an accident on 8/7/2012. Malad, we call for the medical record. According to that, Malad, on 28/6/2012, he has met with an accident and admitted in the hospital for the very same injury. It was not disclosed while filing the petition. During the cross-examination, he denied that he has not met with an accident. When we produced the document, he has admitted that he has met with an accident on that day and he has sustained some fracture. What he said that he has compromised with the owner of the vehicle, therefore he has not the complaint. Thereafter, Melad, on in order
FIR it is stated as
8/7,
Huh?
but 8/7 he has sustained injury, but he has
in the FIR.
8/7.
8/7. But in the cross-examination, how many says by 8/28/6?
28. That's Melad.
27.
We place the
27.
What we do is we'll read from the first.
Melad,
The
exhibit.
case of the petitioner is that on 8/7/2012.
Please.
Okay. Then what about the MLC?
That's what MLC.
Exhibit.
Second, according to Ms. 8/7,
Exhibit R2.
the doctor was examined before the court. He said that night it was misplaced. MLC was misplaced.
That's not placed.
It was not placed. We saw it.
What is that you're relying on?
On 28/6/2012, he has met with another exhibit
R2.
For 7 Miller.
What is that?
R7.
According to that, he has sustained injury on 28/6/2012. Not
Exhibit R.
7.
In the appendix, there
R7
is no that.
R2 matra.
R2 Miller, sorry.
R2.
Give that R2. Yes.
Exhibit to R2 is MLC. Claimed that on 27th there was a prior
Like
accident.
that in your cross-examination, you have accepted that the accident had taken place in 28/6, but you have mentioned it as 8/7.
No.
That is not
their
the
case.
That
Miller.
is
What
not his
they are
case
saying
also.
that earlier I met with an accident. I have compromised with the owner of the vehicle. Therefore, I have not lodged the complaint. Thereafter, I have sustained once again. I have sustained the very same injury in another accident. That is his case.
My lord, that is not.
Tibia fibula fracture, my lord.
That is-
Tibia fibula fracture in the earlier. For that, my lord, according to me, he has compromised. Very same injury was sustained on 8/9.
No, even the injury was also compromised.
Same.
28/6/2022. Brother-in-law, RTA at 7 p.m. on 20, date is something.
27/6.
27/6.
6/2012.
27/6.
27/6/2000.
2012. Multiple abrasions or forehead laceration. Where do you get that? He has sustained fracture.
Please, madam. Swelling and deformity of the
No fracture.
right leg.
Huh?
In the earlier accident, madam.
Looking at this, whatever R2.
R2.
R2
Injuries.
doesn't contain any fracture.
No, it is a swelling and deformity of the right leg.
Hmm.
Referred to ortho.
Hmm.
Please. In the cross-examination, he submitted that he had sustained that.
Let's see that.
ಮುಂದುವರೆದ ಸ್ವಲ್ಪ ಹೊತ್ತಿನ ನಂತರ he said that prior to production of this document, my lord, he said that I have not met with any accident and not sustained any injury. Thereafter, my lord, when we placed before this court, he said that I have sustained injury and I have compromised with the petitioner. That's what the
Come to that.
deposition in Kannada, my lord, I will
Read.
please.
Cross-examination dated 16/4/2016. 16/4/2016.
20
Last page. Last para.
18/4/2018.
18/4. ಅಲ್ಲ 16 sir ಅದು.
No, 18. ಮರುವಿಚಾರಣೆ on 27/6/2012 ಅಂದು ನಾನು ಹಾಸನ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಚಿಕಿತ್ಸೆಗೆ ಹೋದಾಗ ಗಾಯಗಳು ಸೂಪರ್ ಎಕ್ಸೆಲ್ ದ್ವಿಚಕ್ರ ವಾಹನದಲ್ಲಿ ನನಗೆ ಕೊಣನೂರಿನಲ್ಲಿ ಗುದ್ದು ಗಾಯ ಆಗಿತ್ತು ಎಂದು ಈ ಪ್ರಕರಣದ ಬಗ್ಗೆ ನಾನು ದೂರು ಕೊಟ್ಟಿಲ್ಲ, ರಾಜಿ ಮಾಡ್ತೀನಿ. He says that my lord, he has met with an accident and he has not lodged the complaint since he has compromised with the owner of the further he said that my lord, ಈ ಪ್ರಕರಣ ಪರಿಣಾಮಕಾರಿ ಸಲ್ಲಿಸಿದ ಪ್ರಕರಣವು 27 ವಾರ ನಂತರ 10 ದಿನಗಳಲ್ಲಿ ಆಯಿತು. ಎಕ್ಸೆಲ್ ರಂದು 27/6/2012 ಆದ ಅಪಘಾತ ಒಳಗೊಂಡ ಸೂಪರ್ ಎಕ್ಸೆಲ್ ದ್ವಿಚಕ್ರ ವಾಹನ ಯಾರದು ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. He said that man, he has compromised with the owner of the vehicle. We put the question, who is the owner of the? He said that he does not know who is the owner of that TVX Excel. ಅಪಘಾತ ನನಗೆ ಎಡಗೈಗೆ ಕಣ್ಣಿನ ಗುಡ್ಡೆ ಹಣೆಗೆ ಗಾಯವಾಗಿತ್ತು ಹೊರತುಪಡಿಸಿ ಆ ಅಪಘಾತದಲ್ಲಿ ಬೇರೆ ಎಲ್ಲೂ ಗಾಯವಾಗಿಲ್ಲ. He says that except forehead and the left hand, he has not sustained any injury. Subsequently, after some time, he said that right ankle, toe, right ankle toe was
swollen.
ಆಗಿತ್ತು ಎಂದು ಹೇಳುತ್ತಾರೆ. ಸದರಿ ಎಕ್ಸೆಲ್ ವಾಹನದ ಸವಾರ ಆಸ್ಪತ್ರೆಗೆ ನಾನು ಸೇರಿಸಿದರು, ರಾಜಿ ಮಾಡಿಕೊಂಡ ಕಾರಣ ಅವರ ವಿರುದ್ಧ ದೂರು ಕೊಟ್ಟಿಲ್ಲ. ಅವರ ಹೆಸರು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. He does not know who is that owner, but he said that he has compromised. On 27/6/2000 ಅಪಘಾತ ಹೊರತುಪಡಿಸಿ ಬೇರೆ ಯಾವುದೇ ಅಪಘಾತ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನಗೆ ಚಾಲನೆ ಪರವಾನಗಿ ಇಲ್ಲದ ಕಾರಣ, ನನ್ನ ಸ್ಕೂಟರ್ಗೆ ವಿಮೆ ಇಲ್ಲದ ಕಾರಣ ನಾನು ತಡವಾಗಿ ಹೇಮಾವತಿ ಹಾಸ್ಪಿಟಲ್ due to his vehicle was not having a driving license and his vehicle was not having an insurance. Therefore, he has lodged the complaint with the police belatedly. But in this, the injury what is mentioned in 9A 8/7/2012 and the 27/6/2012 are the same injury. For that, my lord,
what is the vehicle according to him on that day when he compromised?
TVS Excel.
Now?
Bike.
Another motorcycle.
He owned a bike.
What is it?
I will explain, my lord. The defense taken by the insurance companies, my lord, on two grounds. That is, my lord, one ground is there is 1.5 delay.
Within a week, every day he'll be getting into one accident or the
Those injuries are, my lord, admitted that those injuries are not the same, because the trial court observes there was a contention taken by the company in the trial court, my lord. In the trial court, my lord, the learned trial judge holds that even though they say that they claim that we are not liable for paying the compensation because there was an earlier accident, the exhibit R2 produced by the insurance company, my lord, is the injuries are different.
You required to file is when you are referred to the ortho on so and so date, what had happened to them?
My lord, that there was earlier that there was the injuries.
No MLC anywhere.
The exhibit R2 injuries were simple in nature. There were abrasion. One ನಿಮಿಷ ನಾನು ಮುಗಿಸ್ಬಿಡ್ತೀನಿ.
Please.
There were.
No, according to you, accident had taken place on
27/6/2012.
Where is the MLC for that?
MLC is produced. MLC is produced by respondent number 2 in the exhibit R2. That is the produce.
Pertaining to 27.
I understood my lord's question. That is my accident that was on 8/7/2012. That MLC is not produced. That is one weakness in my case, because in cross-examination of CW1, the doctor was put a question that saying that MLC was misplaced. So it was not produced.
On
That
this
is like
RW2. Let's see.
RW2 is insurance, the officer.
R2.
R2 is insurance.
No,
1 minute.
MLC.
R2 produces
Government
MLC.
hospital,
RT,
So dated when
that is
that's
27.
accident.
First accident.
I am asking where is the second accident?
The second accident, it is misplaced.
Because
Madam.
second accident, according to you, is a separate, as on the day when you admitted in the hospital.
Correct.
What was your condition? What has happened? What are the injuries? Which vehicle is involved?
So the
And then is a complaint given to the police?
On 9/7.
On?
9/7/2012. That is after 1 day. Explanation to that is, my lord, he was inpatient for 15 days. Because, my lord,
Did it immediately after the next day?
my lord, one logic I would like to bring to the court's notice. The injuries in accident dated 8/7/2012, in which the claimant relies before the tribunal, is the fracture of tibula and fibula. The injury number 3, which was severe in nature. My humble submission would be, my lord, if an accident, according to the respondent number 2's case, if an accident of such a severe nature would have happened on 27,
Simple abrasion.
the claimant would not have waited till 8/7 to get his injuries treated.
But the simple abrasions, nobody will refer a
Will
person
refer him
that.
to ortho.
No, they will not
Correct,
refer.
correct.
They'll not. So they have referred you to ortho.
My lord,
So what happened for that? After
Lord,
that, have you gone to the ortho, or what happened to the injuries?
for that I do not find the
Who has
record.
treated you?
My lord, there the answer given by the claimant in his cross-examination, which my learned friend relies, he says, my lord, there was an abrasion on my right feet and there was a swelling in my right feet, and he did not go to the hospital thereafter for treatment. So he was doing a business of fisherman. He was continuously going in his from
And
village
you
to the
went,
town.
You went in search of this vehicle.
This accident occurred. This accident occurred on 8th.
That's what I'm saying. Without going to the doctor, you went in search of this offending vehicle.
The
Give the
offending vehicle
complaint.
is a later accident, my lord. My lord, the police records also, the spot measure and everything, it tallies, because he was walking on the.
Want to place any medical record, I can remand the matter. But as it stands
that would
now,
serve the purpose, because there was no issue to frame to that extent to the defense taken by the respondent, saying that there was an earlier accident. There was no issue to that effect.
will remand.
Able to produce, my lord, but the doctor said that there is no medical record.
There was no issue framed, and there was subsequently
If it is not, then his case will go. Please come. Agreed with her. Agreed with the award passed in. MVC number 85 of 2013 dated 1st August 2017, whereby the tribunal had granted compensation of an amount of rupees
1,80,000.
1,80,800. The insurance company is before this court questioning the liability. It is a case of the insurance company that the vehicle is not at all involved, only for the purpose of, and that this particular vehicle is implicated in this case. It is a case of the claimant that on 8/7/2012 at the 4:30 p.m., while he was walking on the side of the road, the rider of the Hero Honda bike came in a rash and negligent manner and dashed against the claimant, and as a result, he fell down on the road and sustained abrasion over the knee, abrasion of the outer aspect of right leg, and tibia and fibula of the right leg were fractured. And he was immediately taken to the government hospital, Arkal Voodoo. It is a case of the insurance company that, in fact, he had sustained injuries on 27/6/2012. That was never stated in the claim petition. And after the insurance company has marked Exhibit R2 and adduced evidence, then it's a case of the claimant in the cross-examination that he had sustained injuries, and thereafter he has compromised with the owner and he has not filed the complaint. After that, he has sustained this injury on 8/7/2012, and the injuries that were sustained in the earlier accident and this accident is not one and the same. The tribunal had not considered the case of the insurance company and held that the vehicle is involved and the accident has happened because of the rash and negligent driving of the driver of the offending vehicle, and granted the compensation. Next paragraph. Learned counsel appearing for the insurance company submits that court has failed to consider that there are two accidents. One is on 27/6/2012, other is 8/7/2012. The injuries that are sustained on 27/6/2012 are similar to that of 8/7/2012. The claimant had not stated about the earlier accident, and when they have confronted with R2, with the R2, that is the MLC, then it is stated that he has compromised. It is submitted that it throws any amount of doubt on the case of the claimant, which is crucial and which goes to the root of the matter, and the court had failed to consider the same, failed to consider the submission of the insurance company. It is submitted that the insurance company is not liable as the vehicle in question is not involved in the accident. Next paragraph. When counsel appearing to the respondent claimant submits that the injuries that are sustained on 27/6/2012 and 8/7/2012 are not one and the same. It is submitted that the MLC register was not produced, and no issue is framed to that effect. And without framing an issue and without adducing any evidence, court cannot. Court had rightly not considered the said submission made by the insurance company. It is submitted that without an issue, any amount of evidence that is adduced cannot be looked into. Next paragraph. Having heard the counsels on either side, there is a material on record. This court finds force in the argument of the learned counsel for the insurance company with regard to the 27/6/2012 and the 8/7/2012 accident, and also non-disclosure of the earlier accident by the claimant assumes more significance in the facts and circumstances of the case. It is a duty, no doubt, the tribunal has not framed an issue in this regard. When the insurance company is disputing the accident, and when it is a case that the vehicle is involved, it's a burden lies on the claimant to prove that the burden lies on the claimant to place before the court all the relevant documents, including the MLC, including the MLC register and other medical documents in support of this case. Unfortunately, no such documents are placed in this case. However, considering the submission that both this that an opportunity is given, he would be placing all the documents. This court deems it appropriate to set aside the award and remand the matter to the tribunal for consideration only on this aspect with regard to the involvement of with regard to the accident dated 8/7/2012 and 28/6/2012, the injuries and the vehicles that are involved in the said accident, as even the evidence of the claimant is evasive with regard to which vehicle is involved. When he has compromised, he cannot say that he do not know who is the owner of the vehicle. Accordingly, the order, the award dated so and so is set aside. The matter is remanded back to the trial court to decide the issue. Whatever I said, no, that again paste it here. So and so, without further reference, party shall appear before the court on 22nd September within 5 months from the date of receipt of the copy of the order, the tribunal shall decide the issue. The amount in deposit shall be forthwith transferred, and that shall be kept in a fixed deposit.
I had filed an appeal, which was connected in that, so it will also go.
There is 6.1.
6 point.
The appeal of the claimant in view of the orders passed in MFA number 7573 of 2017. In this order, this matter is also remanded to the court. Where? In this IA number 1021 to condone the delay of 861 days in filing. But the said delay is condoned on the condition that will not be entitled for interest for the delayed period. Yes, next.
Still number 7.
First matter I am for the respondent. In the connected matter I am for the appellant matter.
Yes.
Open.
Yes.
If not challenging the liability on the ground that the vehicle involved is a accident is a LME. Earlier the
That's one.
That's one.
That's the only ground.
That's the only ground.
Income taken by the tribunal is on the lower side, madam.
Case of death or injury.
Case of death.
Case of death, my lord.
Let's
Age
see,
of
where is the
61.
table?
61 years, my lord.
60?
2016 accident, my lord.
Table 22, my lord. Internal page 22.
61 years.
61 years.
How many are the dependents?
Only one dependent. Only
son, my lord, 37.
Huh?
Son, my lord, 37-year-old son.
Major son.
So one is 2016. It should be, how much should be the income?
9,500, my lord.
How much the court had taken?
Court, my lord,
Only 2,000 has been taken, my lord.
Court coming to the conclusion that, my lord, he is not a
Without-
dependent on the income of the deceased. 2,000 income considered, my lord, multiplier system has been adopted. 2,000 into 12 into 7.
Yeah, we'll take 9,500. 9,500. And how much has to be deducted? 1/3.
50%. Lord, here, my lord, fact of this case is different. My lord, 37-year-old, my lord, death of a
No,
mother.
I said in case of wife and husband, we will not deduct 50%.
No, my lord, Vinish Jain case, my lord, Apex Court, my lord, the Vinish Jain case, in Vinish Jain case, my lord, Apex Court held that, my lord, wherever the major sons are there, my lord, they are not depending upon the income of the deceased. I will furnish.
Seema, where will it go?
That is not referred in the Seema Rani's case, my lord. Just, my lord, Pranay Sethi case has been referred, my lord. And
Latest judgment.
no, my lord, and that, my lord, there is no.
In case of binding precedents, same equal bench, the latest one has to be considered.
But, my lord, 50%, my learned friend also agreed that.
On third yearly.
He has not agreed. It seems.
Agreed.
But no, it's not question of agreeing. Unnecessarily it becomes a.
The word, my lord, dependency, my lord, is different to the estate.
Multiplier is 8.
7.
7, man.
Two appeals are there. $6,66,056
Yes.
against 1,98,000. Where is the judgment, Simarani? Agreed whether award passed in MVC number 6218 of 2016 dated 16 December 2017. Both the insurance company and the claimant are before this court. Insurance company's appeal is Insurance company's appeal is MFA number 1428 of 2018, and the claimant's appeal is MFA number 1171 of 2020. What are these translated copies?
The depositions and exhibits.
Positions.
It is the case of the insurance, the claim petition is filed seeking compensation of an amount of rupees 25 lakhs for injuries for the death of the deceased. The claimants are the son and the wife. The tribunal had taken the income at 2000 and granted the compensation as per the table given below. That's it, paragraph number 20 is the table extracted. When it comes to the liability, the tribunal, where is the liability issue? It is a case of the insurance company that the driver is having a license to drive a light motor vehicle, but the vehicle that he was driving is a
LMU.
LME non-transport, my lord. He is having license.
Having a non-transport, he is driving a transport vehicle. LMB non-transport, but he is driving a transport vehicle. As such, the insurance company is not liable. That contention is negatived by the tribunal. Agreed thereby, the insurance company is before this court, and the claimant is seeking enhancement of the compensation. Next part, the land counsel appearing for the claimant insurance company submits that as there is a violation of the terms and conditions of the policy, and as he is not having a valid driving license, the insurance company is not liable. Further, the tribunal had rightly considered and granted the compensation, and no interference is called for. Land counsel appearing for the respondent, not respondent, land counsel the claimant submits that as this accident had taken place in the year 2016, 9,500 are to have been taken. It is submitted that both the wife and the son or the dependents, and the court had to take the income as per the table and has to deduct 1/3 and should grant and ought to have granted the compensation. Land counsel appearing for the respondent insurance company in response to that submits that the son is 37 years old and he cannot be termed as a dependent. He relied on the judgment of the apex court in
Vinish Jain.
Vinish
Jain.
Vinish Jain versus?
Vinish Jain. I'll furnish.
Give it to the court officer. Vinish Jain versus so and so. Land counsel appearing for the respondent, not respondent, claimant had relied on the judgment of the apex court in the Seema Rani and others versus Oriental Insurance Company and others, reported in 2025 SEC online SC283, where the apex court had considered the judgment of the Nation Insurance Company Limited versus Birender and had considered the same as the dependents and accordingly applied the multiplier, accordingly deducted
1/3.
Next part. Having heard the counsels on either side, peruse the material on record. First, coming to the contention of the insurance company with regard to the LMB transport and non-transport. This issue is no more res integra in the light of the judgment of the Honorable Apex Court in Mukund Devgan's case. Still, the insurance company is liable to pay the compensation. Then coming to the compensation, the claimant, the deceased is 61 years. The claimants are the son and the wife. This court, considering the judgment of the apex court in Seema Rani's case, referred to Supra, is inclined to consider the deceased as the son as a claimant, as a dependent, and considering the income as per the table for the year 2016, 9,500, 1/3 is 3,166. If the same is deducted, his contribution to the family would be 6,334 into 12 into 17 is 5 lakh under the head of loss of dependency, 5,32,056. As there are two claimants, 2 into 44, 88,000, 36,000 towards funeral expenses.
Only one person. 44,000.
Son is there.
That's what, my lord. 44,000. Only one dependent.
Wife is there.
No, my lord.
No, my lord. Only one.
No, my lord. Mother death, my lord.
Son is the
death of a
claimant,
mother, my lord.
Only son.
Death of a mother, my lord. Only son. That's what, my lord, my submission.
No, I was under the impression.
No, my lord. If that is so, my lord, I would have submitted that.
Only one.
That's why I'm applying that. Even for dependency also we have to apply Seema Rani.
No, my lord. That's what, my lord.
So
Only
50 we
one
have to
dependent.
deduct. 9,500.
Death of a mother, my lord.
500 minus 1 minute. So 4,750 into 12 into 7.
Yes, into 2. Comes to 3,99,000. Plus.
How much?
4,750 into 12 into 7 is 3,99,000. Plus conventional rates.
12 into 7.
7,
10
399, 3,99,000.
3,99,000. 3,99,000. 44. 36. 10.
Right.
4,79,000.
4,89,000.
79.
No, no.
79.
79,000. 4,79,000.
10 lakh,
10
10,000 legal
make a-
expenses.
Oh.
So, in his contentions, the insurance company, it is submitted that the claimant is the son, who is not dependent. It is a case of the claimant that he is dependent. Considering the judgment in Srimarani's case, this court considers is inclined to consider the claimant as a dependent. 50% has to be deducted towards his personal expenses. That is 4,750 into 2 into 8, 7 is 3,99,000. Loss of consortium 44,000. Funeral expenses 36,000. Legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 4,89,000. Accordingly, the appeal of the insurance company is dismissed, and the appeal of the
The
claimant.
interest, my lord, 8% is right. 6%.
In his contentions, the insurance, the tribunal has awarded 8% instead of 6%. So, insurance company's appeal is partly allowed, reducing the compensation from 8% to 6%. Appeal of the claimant is partly allowed by enhancing the compensation from an amount of rupees 1,98,000 to 4,89,000, which the insurance company is liable to pay. The amount in deposit shall be forthwith transferred. 1 minute. In 7.1, there is a delay of 678 days condoned on condition that he will not be entitled for interest for the set period. And in the operative portion also this should.
Cell number 8.
Docket order as well as operative portion.
Cell number 8. Purti Hegdayan for appellant.
I appearing for claimants, my lord. My lord,
Rajshekar.
kindly grant a week's time, my lord, because appeal memo is not served, my lord. Two matters are connected, my lord.
Counsel first has to appear, then only you will serve. No representation. You are Gunashekar.
No, my lord, Spurti Hegde. On behalf of Spurti Hegde.
The counsel in MFA number 9503 of 2018 is present. No representation.
Well, I am appearing for the respondent number.
Give him the appeal memo.
He is appeal. He wants time, it seems. I don't know.
No, give him the appeal memo. I was under the impression that nobody is appearing for Gunashekar.
No, I am appearing for respondent number 2.
Yes, but that's why Gunashekar are for in MFA number 866 of 2020.
I am appearing for respondent number 2, Swaranamma.
There is no representation on behalf of the appellant in 866 of 2020. List this matter for dismissal tomorrow. Yes. Once he has to come to give you the papers.
Yes, obliged.
Cell number 9.
Yes.
Lord, I am
appellant.
My lord, I am for appellant. My appeal is only for enhancement, my lord. My lord, there are two motorcycle involved, my lord.
No,
I
he's
am,
here, we'll hear him. Yes, Mr. Krishnaswamy.
My lord, my appeal is finding of negligence to an extent of 50% against my insured vehicle. My lord, may kindly see the
It should be
judgment
100%
where-
on him.
Huh?
It is 100% on Mr.
Because-
Shastri's client.
In fact, they were charge sheeted. He has pleaded guilty. He has paid fine. Still, my vehicle has a policy of insurance. Therefore, 50% is saddled on me.
How can it be?
That is what MACT.
Let's see the finding.
My lord,
Then we'll ask him.
my lord.
Come to that
Judgment.
negligence part. Whether the court has recorded with regard to the charge sheet,
Yes.
recorded. Where is that?
My lord, first I request my lords kindly to the issue that was framed. Issue was whether the petitioner proves that he sustained injuries in a road traffic accident that took place on 11/4/2013 at about 3:20 p.m. near Ambika Cross, so and so, due to the rash and negligent driving of the rider of motorcycle bearing number KA 52E9145 by its rider.
Yes.
This is the issue. And a finding is given that as far as two vehicles were involved, both were negligent. This is the answer that is given. Honorable Court, since the
Respondent number
petitioner
3
is
has
successful in
produced
proving
accusation
that
and
he
the order
sustained
sheet of
injuries in
the-
an accident arising out of composite negligence of you.
Who is respondent number 1?
Respondent number 1 is the claimant. He was a pillion rider of motorcycle bearing number 9145.
How can the respondent number 1 be claimant?
no, before this court.
I'm talking about the tribunal.
Oh, my lord, before MACT, she the
Respondent number 1
owner
is-
of motorcycle was,
Respondent number, what are the vehicles involved in the accident?
two vehicles are involved. One
Claimant
is
is going on which vehicle?
KA 52E9145.
What is it? It's a
Motorcycle.
motorcycle. And opposite vehicle is?
Opposite vehicle is also a motorcycle. Bearing number KA 02 HM0383.
So you say because your insured vehicle, the driver of your insured vehicle is at fault.
No, not. In fact,
Arvind, that's what charge sheeted.
in fact, the charge sheet was filed against 9145, rider of
No,
91.
please read, come to paragraph, page number 8, internal page 8 of the order.
8 of the order.
Yes. The respondent number 3, that is about 6 lines from the top. The respondent number 3.
The
has
respondent
produced-
number 3 has produced the accusation and order sheet of the criminal proceedings in which respondent number 1, owner
Insured vehicle.
not mine. That is the wherein the claimant was proceeding as a pillion rider.
Claimant is a pillion rider.
Yes.
Hmm.
No negligence. If there is no negligence, question of composite negligence would not come. My lord, these are the paid the penalty. In addition to the documents referred to above, claimant
No,
petition.
as far as the claimant is concerned, is a pillion rider.
He is a pillion rider.
So whoever is at fault,
Whoever is at fault, yes, my lord is correct.
whoever
My
is
lord,
at fault, he is entitled for because it's a composite negligence of both the vehicles.
my lord, composite negligence would come when negligence is on the part of both the vehicles. This is the, in fact, this honorable court also had taken, Justice Abdul Nazir had taken that view here. My lord, if no negligence is there, if I can establish
Charge sheet is filed against whom?
against 9140,
That is?
where he was a pillion rider, that motorcycle, 9140.
So no.
No material is there to indicate that I was negligent to any extent. My lord, police complaint is large.
Insurer of this
No,
vehicle.
there
on
was
which
no policy.
the party
There was no policy. That is the reason.
to
Owner-
that vehicle in which he is a pillion rider. No policy for that.
That is the reason why they want to fix me for this. My lord,
Let's see, then what did the court say? The
my lord,
respondent number
3
3.
points. One is complaint is against this one 9140. Charge sheet is filed by the police against only this vehicle. And he has pleaded guilty before this, and that document is also before my lord. As exhibit R, I have produced it. My lord, R8, 7 and
No, the
8.
petitioner in cross-examined at length in which it is admitted by him that the accident has occurred on account of negligence of riders of both the vehicles. He admits that the report is filed against respondent number 1, also alleging that the said vehicle is not covered under insurance. Yes, yes, Mr. Shastri. How do you say that it is a
My lord,
composite negligence?
as far as the position of law is concerned, as my learned friend stated, my lord, I am not quarreling. But thing is, it should be this negligence aspect is to be independently proved. That independently deal with in the before the tribunal. My lord, by going through the sketch and other materials, and in the absence of any oral evidence by the insurance company, my lord, the cross-examination of claimant, it shows, my lord, that they are admitted in the cross-examination that the
Is it your case that in every case, when it comes to who is rash and negligent, we shouldn't look at the police records at all?
No. Only in some cases where the claimants are averred in the claim petition and also comes with the before the court that the different from the police records. In such circumstances, my respectful submission is, my lord, the tribunal is to go decide the question of negligence independently, and moreover, I am only a pillion rider. I am only pillion. At any stretch
No,
of
when the rider himself say that it is my mistake, how can you say that it is a mistake?
No, my lord, he plays no such admission is
No, it is there. R1 has pleaded guilty and paid the fine. Who is the rider of the vehicle?
My lord, that is before the criminal court for convenience purpose or other things, my lord.
Yes, I understood that.
My lord, but it cannot be held. It cannot be held that whole negligence is on the part of the my vehicle. That is where I was proceeding as a pillar. And moreover, well, at least 30%, my lord, may be held against my vehicle, where I was proceeding as a pillar. That's why, my lord, and the vehicle, the opposite vehicle is also made as a party, and sufficient opportunity is given to the respondent. Under these circumstances, since it cannot be held at any stretch of imagination that I also contributed.
Yes, I understood. Please come to the enhancement part.
My lord, the accident is of the year 2013.
Yes.
My lord,
be sustained by the claimant.
A comminuted fracture of both the bones of right leg and bone exposed, my lord. He underwent surgery for fixation of steel rod. Thereafter,
in your appeal, owner is served. In your appeal, all are served.
All are served. My lord, split skin grafting also done, my lord.
Served.
Dispensed R1 and 2.
Yes.
My lord, the tabular form, my lord, for first pain and suffering 20,000, my lord, seems to be very low.
Yes.
My lord, it requires enhancement. Loss of amenities, my lord, I examined the doctor at PW2 and the doctor assessed more than 12% whole body.
Come to this loss of income during the later period.
My lord, 8,000 is considered 2013. It is correct, my lord. 12. I have no case on these future loss of earning and earning capacity.
Yes.
A loss of amenities, my lord. Since
you are not on loss of future income also.
No. It's correct, my lord. It's correct. Only pain and suffering and loss of
disability.
12.3% whole body. My lord, he is 45 years and agriculture age.
Yes.
These two heads, my lord, requires enhancement because keeping in mind the lengthy of inpatient period and types of surgery underwent and subsisting.
Where is the amount awarded for attendant and
that No, that is required. 3,000 is only.
How many days he was in hospital?
He was 14 days in Rajshekhar Hospital, first government hospital in Nelmangla for few days, for a few minutes, and thereafter shifted to the private hospital for
How many
14
days he was
days.
in hospital?
Right?
16 days.
16.
CH-13 ಅಲ್ಲಿ 14 days ಅಂತ.
My lord, I am repeatedly requesting my lord about the negligence aspect. My lord,
It can't be.
my lord, if the police papers are looked into, my lord,
Yes.
police papers are looked into.
Yes.
My lord, at least 20 to 30% negligence, my lord, on me, my lord, it may meet sense of justice, my lord. I am not at all of a 50%. Because both are motorcycle, my lord. Both are motorcycle collided in the middle of the road. Merely
No.
because
Now, what police say is wrong, what the rider of the bike says wrong, and what the pillion
I am I am not telling.
Now about
No,
who is negligent.
my lord, I am not arguing that the rider of the motorcycle is wrong. My lord, the only thing is merely because there is a plead guilty order, it may be for his convenience. There is some judgments on that point also.
That we will examine when you appear in the other case.
My lord, well, at least 20 to 30% negligence, my lord.
Agreed with the award passed in embassy number 13 of 2013, dated 26 May 2018. Both the insurance company as well as the claimant are before this court. Insurance company's appeal is MFA number 3367 of 2019, and the claimant's appeal is MFA number 4484 of 2020. The insurance company is before this court on the question of liability. It is a case of the insurance company that the claimant was a pillion rider on a motorcycle, and the opposite vehicle, which is insured by the insurance company, is also a motorcycle.
And there is two pillion riders on that opposite.
The evidence on record clearly shows that the rider of the vehicle, the on which the claimant was riding, was traveling, had accepted his guilt and paid the fine, charge sheet, the FIR, and in all the police documents is shown as the accused. No offense is registered against the vehicle insured by the insurance company. In those circumstances, the insurance company cannot be held liable, as there is no fault, there is no offense committed by, there is no rash and negligent driving on the part of the rider of the insured vehicle. It is submitted by the land counsel for the insurance company that without looking into all these aspects, the tribunal had fixed the liability on the insurance company, and they are not liable to pay the compensation. Next one, land counsel appearing for the respondent claimant submits that the tribunal had rightly considered the police records as well as the evidence of the claimant, and rightly came to the conclusion that there is negligence. The accident had taken place because of the negligence of the opposite vehicle, and had rightly fixed the liability. he submits that when it comes to the compensation, the tribunal had failed to grant a just and reasonable compensation considering the injuries sustained. It is submitted that there needs to be enhancement on pain and suffering, on the loss of amenities, further for the attendant transport and nourishment. It is submitted that the amount that is granted is not reasonable. Next part, having heard the counsels on either side, peruse the material on record. The admitted facts in this case are R1, who is the owner and rider of the vehicle, has been charged against whom the case is registered, and he has pleaded guilty and paid the fine. No offense is written. The driver of the owner of the insured vehicle is not charge sheeted nor is shown as an accused. In those circumstances, the question of contributory negligence would not arise. The contention of the land counsel for the insurance company, the claimant, cannot be considered. And when the rider himself is accepting that he is at fault, and just because that vehicle is not insured, that would not be a ground for this court to say that there is contributory negligence and fix the liability on the insured vehicle in the facts and circumstances. This court is of the view that the vehicle insured by the insurance company, the company is not responsible for the accident in the light of the crime registered against owner of the vehicle on which the claimant is riding, and hence it is alone the owner of the bike on which the claimant is traveling is liable to pay the compensation. Next, coming to the enhancement of the compensation, the tribunal had awarded the compensation as per the table given below. Come to para 16, extract that. As far as the medical expenses, loss of income during the later period, loss of future income, this court do not find any reasons to interfere. Coming to the pain and suffering, considering the injuries sustained by the claimant and the head of pain and suffering, this court is granting an amount of rupees 50,000. For the loss of amenities, 25,000. In the light of the law laid down in Mekala versus so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 4,23,898. Accordingly, the appeal of the insurance company is allowed, holding that the insurance company is not liable to pay the compensation, and it is the owner who is alone liable to pay. The owner on whose bike the claimant is traveling is allowed liable to pay the compensation. Appeal of the claimant so and so is partly allowed by enhancing the compensation from 3,62,898 to 4,23,898, holding that it is the owner alone is liable to pay the compensation. The enhanced amount shall carry 5% interest. The insurance company is at liberty to withdraw the amount.
Number 10.
Yes.
Shashidhara, the appellant. Ravish Bendy.
Yes. Where is he?
Last time also not, it came in the order passed.
Decide it if he's not coming.
The injured is a minor, is a 16 years old student.
Afternoon, if he doesn't turn up, we will pass orders.
Please.
Yes, next 11.
Dhanlakshmi K for appellant. YP Venkatpati.
My lord, I represent second respondent.
For the appellant in this case.
Enhancement?
Only enhancement.
My lord, even on the court has attributed 25% negligence on the part of the claimant, my lord.
Yes.
Because the accident has taken place in a junction where there's no traffic signal and also the traffic police, and in the middle of the road, the court has attributed 25% negligence on the part of the claimant, my lord. May I take your lordships to exhibit P5, which is the sketch, my lord. The court holds that since sketch forms the part of the charge sheet, though he's pleaded guilty and paid fine, the respondent number one, who is the owner of the vehicle, he has been charge sheeted, my lord. He's pleaded guilty, paid fine. The court says that since the sketch is the part of the charge sheet and the same is not challenged by both the parties, so there is contributory negligence on the part of the claimant as well, and holds that there
What do you
is.
say on that? Yes, Mr. Venkatapati. What do you say on that?
Yes, my lord. In this matter, the sketch is produced at exhibit B5 and
No, when the owner of, when your insured says that he's at fault, why should the court look into some other
no,
material?
no. Your lordship will have to see the admissions of PW1 also. Page number 8 of the judgment, your lordship will see at issue number 1.
Yes.
That is fifth line of the observation. During the course of cross-examination for respondent number 2, PW1 admits that, as per sketch produced in PW5, the accident is occurred in the middle of the road and deposed the driver of the car came from cross road and hit to him. So then, your lordship see, the accident has occurred at the junction of the road, and here I have examined the driver at page number 11 of the judgment, your lordship see. From the bottom, it is 1, 2, 3, 4, 5, 7th line. The motorcycle of the petitioner shown to be coming from left side of the road from west to east, and the driver of the car shown to be going in south to north direction, and was almost left the junction at the time of the alleged accident occurred. The police documents exhibit 1 to 9 are not challenged by any of the parties. The contents of the police documents, particularly sketch of the accident spot, oral evidence of PW1 and RW1, prima facie establishes the rash and negligent driving on the part of both the petitioner and the driver of the car. Therefore, the tribunal has rightly come to the conclusion, and it has dealt with the negligence as 75% and 25%, because the tribunal has not rendered any injustice to the petitioner, though he was at fault, because when the car has already crossed the junction and he has come and hit the car. Therefore, actually, total negligence should have been held against the motorcycle rider. Instead of that, in doing natural justice, tribunal has allowed him 25% negligence and 75% against me. Therefore, negligence aspect cannot be dealt with or made as incorrect submission.
Why your insured has pleaded guilty?
Pleading guilty is different, my lord, because 75%, I make submission. Even if 75% negligence is held against me, then also I need to plead guilty because I have no option. But it cannot be told that it is a total negligence. The other person, even if he is not challenged, RW1 evidence and admission of PW1, that cannot go against me.
Yes. Next.
Therefore, negligence aspect cannot be touched. Only appreciation of enhancement of compensation is required to some extent.
Yes, my lord. May I take your lordships to exhibit P5, my lord, the sketch? It shows that though the accident is taken at the junction, I've already crossed the junction. They have come and hit me from behind, my lord.
Come to the enhancement aspect.
Yes, my lord. The accident has taken place in the year 2017, and he was aged 36 years.
Come to the table at page 29.
Yes.
Pain. What the injury sustained by the claimant?
It's the fracture, my lord. Fracture of shaft tibia plus fibula.
Both bone fracture, my lord. Left.
Yes.
He was aged 36.
How many days he was in hospital?
4 days, my lord.
Huh?
4 days, four.
Already enough compensation is awarded, more than required for incidental expenses. So we'll not enhance that.
Yes.
Medical expenses as it is.
Yes, my lord. And the income is on the lower side, my lord.
1 minute. Look at it. So one by one, I'll be Loss of income during later period.
It is only taken for 2 months.
What is the income?
The court has taken 8,000, but it is 11,000, my lord,
Which year is that?
2017 accident.
2017.
Correct, my lord. 11,000 correct.
17, my lord.
17. Court had taken
8,000 as a salary.
Then loss of future earning. Loss of future earning. What is the disability according to the doctor?
Doctor has opened 13% for the whole body, and the court has taken 10%. 10% disability.
Why?
Factors are united, my lord.
So anyhow, we take this income with that. 11,000 into 12 into multiplier.
15, my lord.
15 into court had taken 10.
Yes, please.
It comes to 1,98,000.
Yes.
Then future medical expenses. What is the evidence of the doctor?
Doctor has orally given the evidence that implants are there and it has to be removed, and the cost would be about 40,000 rupees.
We'll give another 10,000.
Your lordship see at page number 18 of the judgment. Doctor has admitted that factors are united. Therefore, 10% taken is appropriate.
Loss of amenities for 10%, 20 is fine.
But requires little enhancement.
It's coming to 4,82,152 against 3,60,152. Please come. Agreed with the award passed in embassy number 3825 of 2017, dated 30th June 2018, whereby the court had granted 3,60,000 as compensation and fixed the contributory negligence. It's 25% on the claimant and 75% on the offending vehicle. The claimant is before this court seeking enhancement of the compensation as well as questioning the liability contributory negligence fixed on the claimant. The facts of the case are the claim petition is filed seeking compensation of an amount of rupees 20 lakhs for the injuries sustained by the claimant in the accident. It's a case of the claimant that on 25/6/2017 at about 4:30 to 5 p.m. the claimant was riding his motorcycle slowly on the left side by following all the traffic rules. When he reached near second main road, at the time the driver of the car was coming with high speed in a rash and negligent manner, endangering the human life, and dashed against the petitioner's motorcycle. Due to the impact, he fell down and sustained grievous injuries all over the body. After the accident, he was shifted to the hospital. When it comes to the rash and negligent driving of because of coming to the aspect of negligence, the court had considered that there is contributory negligence on behalf of the claimant, fixed it at 25%. For this, the court had given a finding that though the contents of exhibit P1 to P9 discloses the rash and negligent driving on the part of the driver of the car, but the sketch got marked by PW1 support that the accident occurred in the middle of the road. As per the sketch, the said road is a double road through which the vehicles passed in two ways divided by a line in the middle to bifurcate the two ways vehicles coming and going vehicles separately. Admittedly, accident space is a junction connecting four roads. The motorcycle of the petitioner shown to be coming from left side of the road, west to east, and the driver of the car shown to be gone in around south to north, and was almost left the junction. At that time, the alleged accident occurred. The police documents are not challenged by any of the parties. Thus, the content of the police documents, particularly sketch of the accident spot and oral evidence of PW1 and RW1 prima facie, establishes the rash and negligence on the part of both petitioner and driver of the car. If they try to move slowly and cautiously, the accident would not have occurred. Responsibility was both on the driver and rider and driver of the vehicle. The responsibility was both on the rider and driver to drive the vehicles carefully on their permitted lines, and they should have carefully observed the movement of vehicles, which is apparently ignored, and traffic routes are violated by them. In the present case, the accident is not disputed. The involvement of the vehicle in the accident is also not disputed. From the police documents, it is seen that the jurisdictional police have registered the criminal case against the driver of the car, and after investigation, police have filed the charge sheet. The police documents have not been disputed by the respondents. The sketch produced at Exhibit P5 is also one of the documents, forms part of the charge sheet, which clearly depicts the sheer negligence on the part of both the petitioner and the driver of the car. The materials produced by both the parties goes to show that the driver of the car and rider of the motorcycle contributed to an extent of 75% and 25%. Then coming to the compensation, court had granted the compensation as per the table given below at page 21. When counsel appearing for the claimant submits that when the police, after a full-fledged investigation, filed the charge sheet and filed the charge sheet, the court, looking at the rough sketch, cannot come to the conclusion that, as these documents are part of the charge sheet, and as the same is not questioned, the liability cannot be fixed on the rider of the fixed on the claimant. It is submitted that the court, without any basis and without any basis had held that there is contributory negligence in the facts and circumstances where the charge sheet is filed against the driver of the car. The court ought not to have fixed the contributory negligence. Next, it is when it comes to the compensation, it is submitted that under the head of pain and suffering, the amount that is awarded by the tribunal is not just and reasonable. Further, it is submitted that the court had taken the income at 8,000. It ought to have taken the income at 11,000. Then coming to the future medical expenses, and the doctor had stated that it is 40,000 that is required. Court had not granted the reasonable compensation. It is submitted that on all counts, the compensation that is awarded by the tribunal is not just and reasonable. Next part, and counsel appearing for the respondent insurance company submits that court has rightly considered the sketch, which is part of the charge sheet, and rightly held that there is negligence on the part of the claimant. In fact, the apportionment of 25% on the claimant, in fact, is on the lower side, and it ought to have been 50%. It is submitted that even the compensation that is awarded is just and reasonable, and no interference is called for. Next part, having heard the counsels on either side, there is a material on record. First, coming to the aspect of negligence, this court is not able to appreciate the submissions made by the counsel for the insurance company as well the findings by the tribunal. The police, after a full-fledged investigation, looking at the, all the, after considering all the aspects, filed a charge sheet against the owner of the vehicle. And in those circumstances, the court ought not to have held that there is negligence on the part of the part of the claimant, considering the fact that already the charge sheet is filed against the driver of the car. This court is of the view that there cannot be any contributory negligence on the part of the claimant. Next, hence, this is answered in favor of the claimant. Then coming to the pain and suffering, considering the injuries, what are the, where do you get the injuries?
Both
My lord.
facts are left leg.
Para 15, my lord, of the judgment. Page 13.
Considering the fractured shaft tibia plus fibula compound, this court is granting an amount of rupees 50,000 at the head of pain and suffering. And as far as the loss of income during the later period is concerned, considering 11,000 as far as the accident is of the year 2017, for 4 months, this court is granting 44,000. Loss of future income 11,000 into 12 into 15 into 10 by 100, 1,98,000. Future medical expenses, this court is granting 20,000. Loss of amenities, tribunal had rightly granted and no interference is called for. In the light of the law laid down in Mekala also so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 4,82,152. Accordingly, appeal of the claimant is partly allowed, enhancing the compensation from 3,60,152 to 4,82,152, which the insurance company is liable to pay. Yes,
And
sir.
the rate of interest is 6% to be done. It's 8%.
No, but it is not your appeal. The enhanced amount shall carry 6%. Yes. No, Paul?
12. Till number 12. Pradeep ji.
Appearing and responding. Appearing for the appellant in this case. This case, my lord, purely on negligence, my lord. I am the insurer of the lorry bearing number KA16C7641, my lord. The initially, my lord, the accident took place, my lord, between the car and the another lorry, my lord. Afterwards, in turn, my lord, the driver of the car was dashed against my vehicle, my lord. I am no way concerned with the accident, my lord. That is insured with United India Insurance, my lord.
No, no. What are the vehicles?
2 lorry and 1 car, my lord.
2 lorries,
And 1 car.
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 The claimant was in the car.
Car, driver.
So car hit which the
Car collision with my lord, MH, lorry number MH09CU 9775. That is insured with United India.
MH01
09 CU 9775.
9775. Insured by?
United India.
You are appearing for that.
That is collision between my car and this lorry. Afterwards, my lord, the driver of the car was dashed against my lorry. After hitting that lorry, I am coming the same way, my lord. I am no way responsible for the alleged accident, my lord. The tribunal coming to the conclusion that the police after thorough investigation filed a charge sheet against both the drivers of the lorry. On that basis, my lord, liability has been fixed to 50-50, my lord. That's wrong, my lord. I am no way concerned with that.
What is the charge sheet says?
That's what, my lord. Charge sheet filed against driver of the both the lorries, but manner of the accident which we see that, my lord, the facts narrated also. The
So
driver
the finding of the court is, had your driver have been careful, cautious, you should have driven slowly, then this accident would have not occurred.
My lord, I am going my path, my lord. I am no way responsible for the alleged accident because, my lord, the car dashed against the initially, my lord, MH lorry.
No, negligence is fixed at 50-50%.
50-50%. Even though, my lord, the driver of the car who is held liable to pay the compensation according to the version of the accident, my lord.
What is that?
According to the version of the accident, the driver of the car who drove the vehicle in a rash and negligent dashed against me, my lord. I am going my path.
He is the deceased.
That is
He
deceased.
is the deceased.
If that is so. But the fact is very clear.
Car driver is no more.
No more. Deceased. The car driver was sustained injury and succumbed to the same in the accident.
And the police, the charge sheet says that
Against both the driver of lorry.
It never says he is negligent.
No.
So basing on what you are saying that he is negligent?
My lord, I am saying that, my lord, I am no way responsible for the alleged
So
accident.
to say that, no, one document that is the police document is against you. What are the other documents to show
Other
or other
documents-
evidence that is let in
No.
to show that you are not negligent?
Other documents, my lord,
My officer was examined as RW1.
rough sketch and spot mahazar.
What it says?
Rough sketch and mahazar, my lord.
Mm.
My lord, in that, my lord,
Mm.
the car which was coming opposite direction was that driver of the car and MH, that lorry
What
driver.
evidence you have adduced apart from?
No, my lord, we have not laid any evidence, my lord. The manner of accident
No.
which
No.
discloses that, my lord.
There is a charge sheet which is filed against your insured. Now, if you have to say that there is something else, you have to adduce somebody, some evidence. Without evidence, why should we take into consideration all these oral submissions?
Not examined anyone.
It has to go then. Come. Agreed with her. Why they have not preferred?
No, my lord.
My lord, I have paid.
You also prefer?
No,
I have paid 50%.
50% they are satisfied.
They have satisfied.
United India.
Agreed with her about passed in MVC number 693 of 2018, dated 13th November 2020, whereby the court had fixed the negligence on the appellant insurance company. The insurance company is before this court. The facts of the case are that on 6/5/2018, the deceased went to Chitradurga along with his wife and children in his car. While they were returning to Hosturga town from Chitradurga at about 5 p.m., deceased was driving the car on the left side of the road. Lorry bearing number MH09CU 9775 being driven by its driver in a rash and negligent manner came from opposite direction and hit the Maruti car. However, when the deceased was controlling the vehicle, another lorry being driven by its driver in a rash and negligent manner hit the car. As a result of which, deceased sustained grievous injuries and died on the spot. The police, after a full-fledged investigation, has filed a charge sheet against the driver and owner of both the vehicles, both the lorries. The tribunal has held that, as per the charge sheet, there is rash and negligent driving on behalf of the drivers of the both vehicles and fixed the contributory negligence at 50% each on both the vehicles. Next one. When counsel appearing for the insurance company submits that, first, the lorry, there was a collision between the car and the lorry. That lorry was not insured by the appellant. Thereafter, the driver of the deceased has hit the lorry, which is coming in the same direction. As such, there is no negligence on the part of the driver of the vehicle, which is insured by the appellant. The court, without considering all these facts, had fixed the liability 50% contributory negligence on the insured. Next one. When counsel appearing for the respondent claimant submits that court had rightly considered the charge sheet and the evidence on record and rightly held that both of them are responsible and fixed the contributory negligence at 50%. Next, in counsel appearing for the insurance company, that is the first lorry, who insured the first lorry, submits that they have already satisfied the amount and they deposited the amount. Having heard the counsels on either side, there is a material not record.
Paragraph number 13.
Paragraph number
13. At internal page 9.
The charge sheet and other police papers corroborate the version of PW1 that the accident was due to rash and negligent driving of the lorries by their drivers.
PW1 is the
PW1 is a
eyewitness.
complainant, is an eyewitness to the scene of occurrence because she was also traveling in the car along with the deceased and others at the time of accident. when and others at the time of the accident. Considering the evidence of PW1 and the charge sheet, court had fixed a liability on both the vehicles. The contention of the counsel appearing for the insurance company, basing on the sketch that it's not the negligence, there is no negligence on the part of the driver of the said vehicle, cannot be accepted. The insurance company has not adduced any independent evidence, but they are trying to take a clue from the rough sketch, and that those submissions cannot be accepted. In the light of the above fact, in the light of the above discussion, this court do not find any reasons to interfere. Accordingly, the appeal of the insurance company is dismissed. The amount in deposit shall be forthwith transferred to the trial court. Yes.
Sir.
No submission.
Second list.
Continue the list.
Serial number 13. List 1, serial number 13.
For the petition, friend, my lord. It was referred to Lok Adalat, my lord. But pay and recovery.
Enhancement?
Enhancement. For the,
Huh?
there
Use
is a
the
pay
mic.
and recovery is there. On
Pay and
the
recovery is already ordered.
order, my lord. On that reason, it was not settled before the Lok
What
Adalat.
about the, it's a, yes,
Sir, present.
come to the compensation.
My lord. In page number, para number 12, my lord.
No, where is the table?
Para number 12 of the judgment.
Well, of the judgment is not the table.
There is no table, my lord.
Then come to
2,50,000, they are,
your synopsis.
total amount has been awarded, my lord. My lord.
It's a global compensation.
Global compensation of
2,50,000.
yes, my lord.
Suppose liability is tribunal against me, company has to file an appeal. Because pay and recovery is there, they have satisfied the award amount.
Okay, let's see how this, no, this court cannot now break up and do all this.
Only 2 lakh.
Particular, you have examined the doctor.
Yes, my lord.
Let us see. Come to paragraph 12. Abrasion
Regarding-
around the left lateral orbital region, edema of upper lip, dento-alveolar region fracture, upper fractures. How many fractures?
4, my lord. All the injuries are grievous in nature. Taking the judicial note
Medical
of
bills?
37,800 881.
37,000?
881.
881.
81, my lord.
How many days was in hospital?
1 day inpatient.
Huh?
1 day. Yes, ma'am.
Then what do you expect the attendant? 1 day, 1,000.
Due to disfigurement and also the
No, let's see.
for
So
that
attendant.
reason, my lord.
And
also
according to the doctor, what is the disability?
40% disability extent to
40% disability to the?
dental doctor has stated that.
For the loss of
Teeth.
40%.
Due to, my lord,
Global compensation.
in this case, my lord,
No, how can it be a disability? No, you lost,
my-
no, if you all
he lost the teeth
lost
also.
a teeth,
Yes, my lord.
there is a procedure to have a permanent implants.
But
for that medical.
Doctor evidence that she cannot chew the food properly, and also it is
No,
very
take-
difficult to add food. She is a coolie, my lord. Due to the not eating a proper food, she is becoming physically weak also. So for future life also
So
disturbed.
there is
my
no
lord.
remedy for that. No, she doesn't have, she lost the teeth.
Yes, my lord.
There is no remedy for that. There is a remedy, she can have an implant.
But the doctor also stated that, my lord. 40% disability is stated.
That we cannot take for the loss of income, we can't
And
have
also-
that.
And also there is a disfigurement, my lord.
What is disfigurement?
They are not produced any photograph, but
I think
physical.
you should be,
No,
you
my
should be
lord.
satisfied with this
No,
amount.
doctor stated there is a
No, I have no pain and suffering, medical bill attendant, 70, 37, 1. It's almost coming to 1,10,000. Where is the remaining amount? Where from we have to add further
that
to
is
that?
income, my lord.
Income.
Yes, my lord.
Hmm.
Accident, date of accident year is 2018, my lord.
Hmm?
2018.
Hmm.
If you take 12,000,
So let's say loss of income. What is the income of that year?
12,500, my lord.
So let's take 12,000, 1 day hospitalization.
Yes, ma'am.
We can't grant more than 2 months for that.
Yes, ma'am.
12,500 into 2, 25,000.
That disability can be considered under
What is the age?
30 years.
She's already married.
Yes, ma'am.
How much according to you for disfigurement?
That is 40% as stated, my lord. 13% has to be taken. 1/3.
You mean to say 1/3 of it?
Yes, ma'am. 10%, my lord. 1/4. 40%.
Let's calculate.
Please, my lord.
What is that? 12,500.
Into 12 into 17.
So if in this calculation, if we arrive at an amount less than that, Then also I'll record and reduce it. With his calculation, it will come to 2,55,000.
Yes. In the disability aid, my lord. Disability, it will come around.
What disability?
13%, it means 3,31,000, my lord.
If you lost teeth, it can't be disability. There is a remedy for that.
She is doing a coolie work, my lord. That is the
Anyway, you are
physical,
seeking compensation from them. So you will seek compensation under the medical. Why did you go home if you lost all the teeth you kept quiet? You should undergo some treatment, and the money the insurance company you can claim. It can't be a disability at all. Loss of future income. How can there be a loss of future income for that? At least we can understand. Okay, loss of amenities.
Yes, ma'am.
Amenities can't be that much amount you will get. 2 lakh, how much it is? 90,000.
2 lakh.
Good compensation that's awarded. Please come. What is this MBC? Double one?
1136 of 18, para number 11.
Agreed with the award passed in. MBC number 1136 of 2018.
Regarding disfigurement, also disfigurement, there is a. She has to suffer lifelong, my lord.
Yes, that's why I've calculated.
Lifelong she has to suffer.
In other heads also, you're getting that much amount. 2,50,000. Now, according to my calculation, it's coming to some around, even if I add something, amenities and all, it won't be 2,50,000. Already enough the court.
There is a disfigurement for that reason. Judicial note they taken, my lord. On that reason, they globally awarded 2,50,000.
Agreed with the so-and-so. 1136 of 2018. Dated 17 March 2021. Whereby the tribunal had granted global compensation of an amount of rupees 2,50,000. The claimant is before this court seeking enhancement of the compensation. Then counsel appearing for the claimant submits that the claimant is aged 45 years.
30 years.
30 years. She lost her teeth in the accident that led to disfigurement. And it would have, as she's not able to chew the food, it would have an impact on her, on her future earnings. The court had not granted reasonable amounts, hence there needs to be enhancement. Then counsel appearing for the respondent insurance company submits that the court had already granted a compensation of 2,50,000. It requires no enhancement. It is submitted that the compensation that is awarded is on the higher side. Next part. Having heard so and so, there is a material on the court. The claimant is in hospital for one day. What is the doctor has deposed that she'll not be able to depose. Admittedly, she lost the teeth. When there is a treatment available for having a permanent implant, that cannot be termed as a disability. At best, it could be as disfigurement or the impact of it. It could be for the loss of amenities. The claimant is entitled for the amount. Looking from any angle, the amount of rupees 2,50,000 that is awarded by the court is a just and reasonable compensation. This court do not find any reasons to enhance. Accordingly dismissed.
Cell number 14.
National income they have taken less, my lord. Accident is of the year 2018, my lord. National income is 12,500, my lord. The tribunal has taken just 10,000 only, my lord.
The order sheet. Was he there?
Mahesh for R2, R1 is sold.
Was he there on the last occasion?
Order sheet.
14.
Serial number 14. I appear for the appellant Malad in MFA 5583 of 2009.
On what ground you are before this court?
Malad, on the ground that there was no employment and there was a collision between the insured and the injured, my lord, for an accident which has occurred somewhere else.
Hmm. Please come to the particular paragraph you will read.
Hey. But my grounds may kindly be looked into before I take your lordship through this thing.
With the next appeal, there is the order is not clear at all.
Hey. Then, my lord, I'll invite your lordship attention to
Oh, these
ink
kind
page,
of awards can be
page
filed.
31, my lord, para 8.
Why they have not taken update? This is also like that.
May I read, my lord?
Which where? Yes.
Para 8,
Paragraph
my lord. Para 8.
Yes.
Petitioner being husband and children and legal representatives of the deceased Jaya are entitled for compensation for death of Jaya. Honorable Apex Court of India in case of Srimati Sarala Verma reported in AR 2009 SC, page 3104, was pleaded to lay down norm and principles to assess the compensation on differentiate in case of death in motor
No, we are
accident.
on the point. No, you're arguing on the liability. Where is that? Where
Yeah,
is
that
that?
2 points, my lord. One is, my lord, the inquest Panchanama shows
Hmm.
fall from a coconut tree fell on her.
That's why please come to a discussion on that. No, this discussion which you are inviting the court's attention is about her income and all.
Yeah. Now, my lord, paragraph 7, my lord.
Please read.
In page 30.
Yes.
Lokesha, who is none other than the husband of the deceased Jaya, has given evidence to the effect that when himself and his wife Jaya had been there near a manure pit situated in his coconut garden land to transport organic manure from the said pit to their land through tractor in question. The said tractor, driven by the Lakshmana Gowda in a rash and negligent manner, rammed on the standing dried coconut tree while it was reversing. As a result of it, standing dried coconut tree fell on his wife, and his wife, who sustained injury, died at the spot. PW1 has further clarified that his wife was standing at a distance of 2 feet from him and tractor rammed standing coconut dried tree while it was reversing. He has admitted that the said tractor belongs to his village and the same was driven by his villager. Nothing was brought out in the examination of PW1 to discord his evidence. Thus, oral testimony of PW1 have not been discredited in the result of the oral testimony of your first petitioner is
Incident
credible.
had taken place on what date?
Pardon?
Accident had taken place on what date?
The date, my lord, on 3/4/2018 at 9:30 a.m.
When was the report?
Yes. My lord, Exhibit P4, my lord, is the FIR. By husband, my lord, on 3/4/2018.
At what time?
My lord, at
9:30 a.m.
9:30.
This is accident. When was it reported to the police?
That is 3 3 o'clock, 12 minutes, my lord. At 3:12 in the afternoon, in the noon.
Yes. Postmortem report is marked as?
Postmortem report, my lord, is exhibit P6.
Give it.
Inquest may kindly be looked into, my lord. Exhibit P9. There is no mention of, my lord, the tractor dashing against the tree and tree filling on her. Inquest on 3/4/2018.
What is this?
At, my lord, 3 p.m. In Roman 3, my lord, it is stated ದಿನಾಂಕ 3/4/2018 ಬೆಳಗ್ಗೆ 9:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಅರೇನಹಳ್ಳಿ ಗ್ರಾಮದ ಮುಂದೆ ಅರಮಂಜೆ ಮುಂದೆ ಜಯ ಅವರ ಮೇಲೆ ತೆಂಗಿನ ಮರ ಬಿದ್ದು ಮೃತಪಟ್ಟಾಗ ಪಕ್ಕದಲ್ಲಿ ಇದ್ದ ಸೋಮಣ್ಣ. There is no mention of, my lord, the tractor having hit the, my lord, the coconut tree, and coconut tree fell on her. Before the tribunal, it has been stated that she was working
Copy of the FIR.
in the land.
Read. At what time it is given, complaint? Should you mention date, you'll get it, date and time.
On 30/4/2018 at 3:12 p.m. FIR, my lord, exhibit P4.
18 undo. Where did they mention about the law, tractor and all? Understood. Then inquest Panchanama, what is the time of exhibit P9?
Inquest, my lord, there is no mention of the tractor.
At what time it is? Somewhere in the beginning or end. YouTube. Not time of accident. When this inquest Panchanama is done, there is there no time. Dinams 3/4/2002. That is one submission. Yes, what is the other submission?
Pardon me?
That is one submission.
Yes, madam. Then, my lord, it is stated, my lord, that deceased, as per exhibit P9, my lord, household wife. She is not gainfully employed doing any this thing, but claimed as a coolie. Claim was that she was a coolie earning rupees 30,000 per month.
What is the time? Time. Yes.
Yes.
Now come to the order on compensation. What is the submission?
The company that she is a housewife and say that coolie, which is contrary to, my lord, their own document, exhibit, my lord, P9, which says that she housewife. Now the tribunal, my lord, before the thing, they are claimed 30,000 rupees per month as a coolie. This is was age 38 years. That is the claim.
Court had taken how much income?
Court has taken 10,000 per month.
According to them, it is 20,000.
And future prospect, my lord, 25% has been added. Totally 12,500, and 1/3 has been deducted.
Why 25% is taken? She is 38 years old.
40% have to take, my lord.
40% has to be taken.
Future
Which year is
prospect.
that?
2018, my lord.
According to me, my lord, she was not employed. She was not employed at all. She was a housewife.
That we will consider. 12,500.
National income, 40,000, 40% has to take.
Income does not come into picture at all when she is a housewife or not earning anything. If that is so, then only the minimum wages notification has to be taken into consideration.
Who are the dependents?
Husband and 2 children, my lord.
And 2 children, my lord. Son and a daughter, aged 13 and 10.
What is the multiplier?
15, my lord. 40 years, my lord, age.
15 multiplier has been employed by the tribunal. The split up of the award may kindly be looked into. 40,000 for loss to the estate, 15,000 transport, burial and obsequies, 40,000 loss of consortium, 1 lakh for loss of love and affection, and 80,000 for filial consortium, all duplicates. %9 interest has been made.
Yes, that will make it 6%.
Consortium, my lord, 10% increase, they have not taken, my lord. Consortium, 10%.
Consortium, there is a, as per it, 44,000 into claimants and 36,000, that's it.
Please, ma'am.
1 lakh love and affection, 80,000 again
That
filial
as per we
consortium.
are not going to take, Mr.
Yes.
Mahesh, as per 3 into 44, 1,32,000. 36,000 towards funeral expenses. Yes, please come. The agreed with award passed in MBC number 969 of 2018 dated 13th March 2019. Both the insurance company as well as the claimant are before this court. Insurance company appeal is MFA number 5583 of 2019 and the claimant's appeal is MFA number 5057 of 2021. The claim petition is filed seeking compensation of an amount of rupees 20 lakhs for the death of the deceased in the accident. The claimants are husband and 2 children. It is a case of the claimant that the driver of the tractor drove the tractor in a rash and negligent manner and rammed standing dried coconut tree while it was reversing, as a result of which standing dried coconut tree fell on the deceased and sustained injury and succumbed to the same at the spot on 3/4/2018 at 1:30 a.m. And according to them, deceased was earning 30,000 per month from agriculture and animal husbandry and is also a homemaker. The tribunal has held that the accident had taken place because of the rash and negligent driving of the driver of the offending vehicle. The court has observed that the Exhibit P7 charge sheet, final report of the jurisdictional police shows that driver of the offending tractor was charge sheeted for having caused the death of the deceased due to rash and negligent driving of the tractor in question on material date, time and place. In support of allegation that the driver of the tractor rammed standing dried coconut tree, fell on the deceased, and deceased died at the spot. The Exhibit P4, FIR, Exhibit P5, copy of the FIS, Exhibit P6, copy of the postmortem, Exhibit P9, copy of the inquest Panchanama, Exhibit P8, copy of the Mahajar, support the final report of the police. Unrebutted medical document, Exhibit P6, copy of the postmortem report, shows that due to hemorrhage and shock resulted from the head injury and other multiple injuries, she died. And accordingly, the court has held that because of the negligence, rash and negligent driving of the driver of the tractor, the accident had taken place. When it comes to the compensation, court had granted the compensation as per the table given below at paragraph number 8. The court had taken the income at 10,000 and by granting 25% future prospects, the court had granted the compensation. Next para. Then counsel appearing for the insurance company submits that in the inquest Panchanama, it is nowhere stated that the accident had happened because of the rash and negligent drive, that in the accident a tractor is involved And nowhere, and in the inquest Panchanama, it is stated that she is a housewife. And when it comes, before the court, it is submitted that she is a only earning 30,000. There is no connection between the two statements, and court ought to have considered her as a housewife. Once she is a housewife, question of taking the notional income will not arise. It is submitted that on these two grounds, the order impugned needs to be interfered with by the court. Next paragraph. When counsel appearing for the not respondent, when counsel appearing for the claimant submits that court had failed to take the notional income at 12,500, as this is an accident of the year 2018, it is submitted that she is aged 38 years. The future prospects ought to have been taken at 40%, but the court had taken the future prospects at 25%. Even on the other hand, also the compensation that is awarded by the tribunal is not just and reasonable. Next para. Having heard the counsels on either side, person material on record. First, coming to the contention raised on behalf of the insurance company that in the inquest there is no mention about the auto, and also that it stated that she is a homemaker. In those circumstances, homemaker. First, coming to the inquest about the income and about mentioning of involvement of the tractor in the inquest. This court has perused all the documents. The accident had taken place at 9:30 a.m. A report was given in this regard at 3:12 p.m. Immediately after as she succumbed to the said injuries, immediately she was taken to the hospital and a postmortem is conducted. And in the inquest report, mere not mentioning about the auto cannot be a ground to there cannot be a ground for this court to take a different stand from that of what has been taken by the tribunal. Tribunal has rightly discussed all the material and rightly held that there is an excess. Rightly held that the accident had taken place because of the rash and negligent driving of the driver of the tractor. Considering Exhibit P4, P5, P6, P9, and P8, this court do not find any reasons to take a different view, and the tribunal had rightly held it, and in its submission with regard to that 9%. Income is at 9%. Interest it has to be rated. Then coming to the second, then now coming to the aspect of the income, the court had observed that the court has fixed the government of India fixed a minimum wage of the unskilled labor to be paid at rupees 350 per day, and unskilled labor gets to be 350 per day. And the deceased, being a member of an agricultural family and milk producer, could definitely earn more than rupees 10,000. In the exhibits, exhibit is a card of the milk producer cooperative society, and exhibit P11 is a copy of the RTC. These contentions makes it very clear that
RTC stands in the name of mother-in-law.
That she comes from an agriculture family, and the contention that she works as a coolie, and also like she is supplying the milk to the cooperative society. In these circumstances, this court is inclined to take the minimum, take the income at rupees 12,500. The age is 38, and the future prospects have to be taken at 5,000. 40%.
40% is 40 years.
She is?
40 years is the held age by the tribunal.
Is it 38 years? Where is the, let's look at the postmortem report. What did they say?
Ink page 33, bottom few lines per hour.
1 minute. Let us see from the Postmortem
40%,
report.
yes, which has to be rounded off.
What is that? Postmortem report is exhibit?
My lord,
No, exhibit
P6, my lord.
P6, my lord, P6. P6.
So, in exhibit P6, age is mentioned as?
Forty. Third column, my lord, in the age column, 40 is mentioned.
And 25 only can be taken.
My lord, they have taken increase only 25%. They have to take 40%.
How?
They, for the age.
As per the postmortem, her age is 40 years.
Please, ma'am.
So, if if it is
Prospective
percentage of future prospects, 40%.
Please, my lord.
It'll be 20.
No, 40 years it is 40%.
40%.
40 to 50 is 25%.
20.
25.
She is 40 years age, my lord.
That's why 25%.
Well, unsecured job, not secured.
No, my lord. In the first slab, up to 40 years, it is 40%, my lord.
You are looking at a permanent job.
50.
You are looking at a permanent job.
No, my lord. Second paragraph. Self-employment, 40%, my lord.
40% below 40 years.
Up to 40 years, my lord.
Not up, yes, up. She is 40 to 50 is 25%.
No, my lord, it is 40%, my lord.
Even if you dispute on that also, I can't do anything. It's as per the table. Give him the table. Read the second column.
Self-employed establishment. Yeah, apologies. Please, ma'am.
40 to 50, 25,000.
Yes.
25%.
Yes.
Secured job. Secured job, 30%.
I under the impression that she is 38, I have taken that. It's coming to 20 lakhs 53,060. So what is 40? Her age is 40. Future prospects have to be taken at 25%. It comes to future prospects at 25% would come to 3,125, and the salary is 15,625. In that, the 3,625, 1/3 has to be deducted towards the personal expenses. That is 5,208. Then the contribution to the family would be 10,417 into 12 into 15 is 18,75,060. And there are 3 claimants under the head of loss of consortium. 3 into 44, 1,32,000. Shundal expenses 36,000. In the light of the law laid down in Mekala versus so and so, 10,000. Altogether, the claimant is entitled for an amount of rupees 20,53,060. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 17,80,000 to 20,53,060. The insurance company appeal is partly allowed by reducing the interest from 9% to 6%. The amount shall carry 6% interest. Yes.
Much obliged.
The amount in deposit shall be forthwith transferred to the trial court. 268 days condoned that they are not they are not entitled for interest for the said period. Yes. Yes.
Serial number 15.
Paper for appellant, madam.
Entire, that percent is on the entire amount, not enhanced amount. Yes.
Paper for appellant, madam. This is the
appear
injury.
for the respondent CH-18.
My lord, the accident was occurred on 22nd.
Where is the table? Straight away come to the table.
Page.
Yes, my lord. My lord, it is at page number 20 of the judgment. 20.
Yes. What
Pain
are
and
the
suffering injuries, my lord, it is at
My lord, may I read? Injuries of tenderness on back of the chest. In
How
the
many
middle.
grievous injuries?
There are more than 3 injuries. Fracture,
Is it
spinal
so?
cord.
Then
He is suffering
60,000
from paraplegia, my lord.
60,000 is a reasonable amount for that. 3 injuries.
My lord, in this case, my lord, the appellant has not examined the treated doctor. Though the treated doctor has produced the disability certificate, he assessed the disabilities.
But he has to be examined.
His colleague was examined. He passed a PW2, who is also assessed the disability. The tribunal has not considered the
What do you say on
disability.
that?
50% disability was.
Your lordship may kindly see, my lord, I take your lordship's kind attention to typed page number 17 of the judgment, para number 28. The petitioner has claimed that after the accident, he is not working in Alvas Institute and become jobless. In support of this contention, Ullas Setti PW3 and got marked a disability certificate exhibit P14. PW3 in his evidence has stated that the petitioner has got permanent physical disability at 50% with respect to whole body. The respondent has disputed correctness of the evaluation of the disability by PW3. Admittedly, PW3 has not treated the petitioner at any point of time. PW3 has claimed that he, along with Dr. Dheeraj, assist the
We will remand this
disability.
matter.
Yes,
We'll remand this matter.
please, madam.
Yes. Examine the doctor. Agreed by the about past name is number 966 of 2018, the 31st of December 2020, whereby the court had granted compensation of an amount of rupees 9,18,686. The claimant is before this court seeking enhancement of the compensation. Learned counsel appearing for the claimant submits that the court has not considered the disability as assessed by the doctor only on the ground that he is not a treated doctor. It is submitted that when a disability certificate was produced and the doctor was examined, court ought to have considered the same. Next para, learned counsel appearing for the respondent submits that the court had rightly considered the evidence and granted the compensation and there are no grounds to interfere. Next para, this court as per heard so and so per is the material on record. The court had observed that admittedly PW3 has not treated the petitioner at any point of time. PW3 has claimed that he, along with Dr. Dheeraj, assessed the disability in of the petitioner and gave the disability certificate marked as Exhibit P14. And PW3 is a medico-legal consultant in AJ Institute of Medical Sciences, Bangalore. Further, PW3 has not produced any document before the tribunal to show that he has examined the petition for the purpose of assessing his disability, except signature of PW3 found in Exhibit P14. On the other hand, the medical records available before the tribunal goes to show that the petition was treated by Dr. Dheeraj, who is a consultant orthopedic spine surgeon. It is not the case of the petitioner that the doctor is not available for his examination before the tribunal. Thereby, it becomes clear that the claimant has failed to place best evidence before the tribunal to prove his alleged physical disability. On this ground, the court did not consider the disability. Next parallel, counsel appearing for the petitioner claimant, for the appellant claimant submits that when he had sustained 50% disability, court ought to have considered it. This court has perused the said finding of the court. The court had not considered the evidence of the doctor only on the ground that the treated doctor was not examined, and the doctor who has given the disability certificate has not given a proper evidence that the claimant had sustained disability. A perusal of the said observation of the court. This court is of the view that that it would be in the interest of the balancing the interests of the parties. It would be appropriate to remand the matter so that the claimant, facilitating the claimant to adduce evidence in support of his disability. In that view of the matter, in the light of the above discussion, the award dated so and so passed by so and so is set aside, and the matter is remanded back for fresh consideration to the tribunal. As far as the disability of the claimant is concerned, the same shall be as far as the disability of the claimant is concerned, the court shall consider and pass appropriate orders. Number 2, without further reference, the party shall appear before the tribunal on 25th of September. Within 6 months from thereon, the court shall dispose of the matter. Both the parties are at liberty to adduce evidence as far as the disability of the claimant is concerned. Yes.
Cell number 16, Gopal Krishna N for petitioner appellant.
In this case, my not feeling well, sore throat, kindly have next week, madam.
Yes, both the matters not next week, posted in the month of October. Yes, next.
Cell number 17.
Yes.
My lord, the claimant's appeal seeking enhancement of the compensation, my lord. During the pendency of the appeal, my lord, she has incurred additional medical expenses, my lord, that were produced along with the application, my lord.
Have you served on him?
I have served.
Have you filed any objection? When do you want?
And you remand the matter to prove that those are approved.
Only to that limited extent.
My lord, the enhancement of the compensation I am seeking in the appeal, my lord, in addition to that.
No. What I'm saying is, as far as that aspect is concerned, let the tribunal decide only that aspect and send it back. And we will enhance the compensation.
My lord,
we will consider that aspect. At a time, we have to dispose it all. As far as this application at order 21, order 41 rule 27, whatever you filed, with regard to the entitlement, let the tribunal decide.
So far as the medical bills are concerned, send a report to the honorable court, my lord, evidence. That could be done, my lord, but the entire records has to be sent back, my lord, for
will
that
again
purpose.
Come back once it is decided.
My lord, the difference of medical expenses would be only about 45,000 rupees.
Then leave it. We'll consider the other things. Or why don't you get instructions?
Future medical expenses, my lord, I have.
Why don't you get instructions on that instead of remanding the matter?
Ask our office, the demand how genuine they are questioning the genuinity of those. That is all.
Yes, an application is filed under order 41 rule 27, wherein it is the documents that are the documents are filed to show that the claimant has incurred 45,000 expenses.
No, my lord. My lord, she has incurred, my lord, medical expenses of 1,04,556. But my lord, MACT has awarded 60,000 future medical expenses, my lord, while passing the award.
No. What is this additional evidence?
If future medical expenses were excluded.
That's what I'm saying.
Then
what
my lord,
spent.
it
now
will
we
be
are only on that point. on the point that what is the application you have filed for
The
it?
application, my lord, I have produced that I have incurred medical expenses of rupees 1,04,560.56.
Hmm.
But while passing the award, my lord, MACT has awarded 60,000 towards future medical expenses. So difference would be, my lord, 45,000.
So then they're already marked before the tribunal, then what?
My lord,
what
these
is
medical
the,
bills were not marked, my lord. My lord, in the evidence I have stated that for future medical expenses, I may require about 60,000. That was awarded by MACT. But my lord, I underwent future medical operations, and my lord, I had incurred 1,05,000 towards the expenses. So,
so about another 45,000.
Yes, my lord.
Hmm. The an application under 41 Rule 27 is filed stating that
My lord,
for the
instead
future
of-
medical expenses.
For 45,000 instead of remaining lordship may compensate in other heads.
Yes,
But a case of injury, my lord,
please come to that.
is
Where is the table?
table, my lord, gets it 23, page number 23, para 30, my lord. Running page 30. Para 30, my lord.
What are the injuries?
My lord, injuries, there was a crush injury to the right foot, my lord, and there was amputation of third, fourth, and fifth toe of right foot.
Hmm.
My lord, for a moment, may I take, my lord, exhibit P 12, my lord, disability certificate. But she lost all.
No, pain and suffering. First, we will complete that.
Yes, ma'am. 85,000 was awarded, my lord. She was inpatient for a period of 36 days in the hospital, and there is amputation of 3 toes, my lord.
What do you say? Pain and suffering.
Make it 1 lakh. Another 15,000 for that.
Yes.
Then, my
Next,
lord,
loss of income. Look at the table.
income was 13,250 was taken, my lord. Her evidence was that she was working in under her husband, my lord, as a helper in a cargo company, and my lord, she was earning about 25,000 is her evidence, my lord. 18,000 was.
As per the chart?
14,000.
Court had taken 13,500.
250.
Hmm. So, how many days she was in hospital?
36 days, my lord.
2, 4. It comes to 56,000.
My lord, MACT has taken for a period of, my lord, 4 months.
I'm also taking 14,000 into 4.
My lord, more than a month she was inpatient in the hospital, my lord, a crush injury to the right foot.
Hmm. So now it's already compensated. We'll stop here.
No.
Calculation. Then loss of amenities.
Amenities, my lord, only 20,000 was
What is
awarded.
the disability?
Disability stated by the doctor, my lord, 44% to the
Limb.
right lower limb, my lord.
And to the body, how much is taken?
My lord, nothing is stated. My lord, MACT has taken 14%.
14%.
My lord, may I persuade my lord to look into disability certificate for a moment, my lord. Her position of leg, my lord.
Exhibit P12.
Exhibit P12, disability certificate, and photographs, my lord, at P. And P16, my lord, photo. There, my lord, disability certificate photos are, my lord, enclosed at page 1 of the disability certificate.
Present patient is able to work without support, no wounds.
Yes.
Able to carry out activities of daily living with modification.
The condition is non-progressive but may need a cosmetic surgery to
It is
improve
not
the appearance.
progressive, but may need cosmetic surgery to improve the
Appearance and
clearance
form of
from the right foot
by doing surgery.
So, as far as her income is concerned, there cannot be any difficulty. It is only cosmetic.
My lord, the disability has.
Yes, that was correct. Then loss of amenities.
My lord,
What do you say about loss of amenities?
my lord, permanent disability, if the income is taken, my lord, there will be.
1 minute. Huh? Yes. Compensation for permanent disability. Yes. Loss of income due to disability.
If 14,000 is taken, my lord, and the same.
So 14,000 into 12, what is the multiplier?
13, my lord.
into 14 by 100.
3,05,760.
It's coming to 3,05,760. The medical expenses as it is.
Yes, ma'am.
Four lakh 22,562. Future medical expenses. It's 3,000. How many days was in hospital?
36 days, ma'am.
We'll grant 36,000 on conveyance, attendant and nourishment. It's coming to 10,34,322 against 9,42,942. Around 90,000.
Yes, ma'am.
Please come.
6% interest. MACT has awarded a 9% interest, ma'am.
Why anyway, he has not filed any appeal.
Yes, ma'am.
Their appeal is there.
No, my lord.
We'll say enhanced amount 6%. Agreed by the award passed in MBC number 1485 of 2018. Dated 26 July 2022. We'll say that on your application under 4127, like those documents cannot be considered. 26 July 2022, whereby the tribunal has awarded the compensation as per the table given below at paragraph number 30. The claimant is before this court seeking enhancement of the compensation. It is submitted that the court had taken the income at 13,250.
Yes, my lord.
250, and as per the table, it ought to have been taken at 14,000. Even under the head of pain and suffering and loss of amenities, loss of income during the later period, and for conveyance and attendant charges, the amount that is awarded by the tribunal is not appropriate. It is submitted that on all counts, the enhancement needs to be, the compensation needs to be enhanced. Next para. The land counsel appearing for the respondent insurance company submits that the court had rightly granted the compensation and there are no grounds to interfere. It's having heard so and so, so and so. This court has perused the injuries that are sustained by the claimant. Where do you get the injuries?
My lord, I have extracted in the synopsis.
The petitioner has suffered complete crushed injury to the right foot. And in the synopsis, the claimant had sustained deglobing injury, crush injury to the right foot, near total avulsion of third, fourth, and fifth toe, lacerated injury over the scalp, bone with soft tissue or right foot exposed. Considering these injuries and the head of pain and suffering, this court is granting an amount of rupees 1 lakh. Coming to the loss of income during the later period, considering the hospitalization of 36 days and the crush injury for 5 months. Huh?
Because of French injury, 3.
The 14,000 into 5, 70,000. The court, the doctor had opined that the disability is 14% to the court. The tribunal had taken 14% disability to the whole body, and this court do not find any reasons to interfere with the same. Hence, on the head of loss of amenity, this court is granting 30,000. Then coming to the loss of income during the later period, 14,000 into 12 into 13 into 14 by 100 is 3,05,760. Medical expenses, for medical expenses, future medical expenses, this court is not interfering. Coming to the conveyance and attendant and nourishment, considering 36 days of hospitalization, this court is granting 36,000. In the light of the law laid down in so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 10,34,322. Accordingly, appeal of the claimant is partly allowed by enhancing the compensation from 9,42,942 to 10,34,322. Enhanced amounts will carry 6%. 6%. Then an application is filed under Order 41 Rule 27. Certain medical bills are filed. The looking at the medical bills, and they're all the Xerox copies.
No, my lord. Original I have produced. Lordship may say before the MACT, the evidence was that future medical expenses require 60,000. That was awarded.
Before the MACT, it is already stated that they require only 60,000. Now, at this stage, this court cannot consider all these documents. Accordingly, the application that's filed in Order 21 Rule 20, or 41 Rule 27 is dismissed.
Please.
Yes.
18.
Take this. You can give it back. Yes.
For second respondent.
Who appears?
Time for the second respondent.
Yes.
Two appeals by the claimants, my lord, seeking enhancement of the compensation, as well as on
Page 663 arises out of
63
MBC
arises
649.
next one.
650 MEC.
Yes, let's see.
My lord,
649. Where is the table?
Lordships get it at my lord, page 14.
My face 663 of 2023. Yes. Page?
14, my lord.
Paragraph. Refer to paragraph.
Internal page 11 of the judgment, my lord.
Paragraph is not forthcoming, my lord.
Table is where?
Internal
Table
page.
is at, yes, I've seen it. 3,74,000 is awarded.
Yes, my lord. The question of liability is also called in question, my lord.
Liabilities on whom?
My lord, liabilities are fastened on the owner, my lord.
On the ground?
On the ground that the premium paid towards the policy, my lord, check was bounced. Therefore, my lord, the insurance.
Was it informed before the accident?
My lord, that is a grievance, my lord. The RW1 was tendered evidence. My lord, administrative officer of the insurance company. He says, my lord, they have sent it by post, my lord, intimation to the.
Acknowledgement is filed.
Acknowledgement was not filed.
Yes, acknowledgement
Only-
is filed.
My lord, postal
With
receipt
the
was
postal
produced,
receipt
my lord.
also is being filed, much before the accident, my lords.
No, that's acknowledgement.
Yes,
Saying
yes.
that when you send RPID, then you get an acknowledgement.
Yes, that
about
is
it.
what is filed.
That was not produced.
Let's
That
see.
was filed.
Let's see. Please
It is
come to
exhibit.
the appendix. What are the exhibits?
RW1's evidence, my lord, may take.
If it is, then nothing to go into it.
Yes.
Cancellation insurance policy, original check.
My lord, it is at exhibit
Notice with receipt given to
R8,
R2.
my lords.
Look at it, exhibit R8.
Notice with receipt given to R2.
Yes.
My lord, in the cross examination, my lord, RW.
Let me just see. That
Yes.
receipt itself is sufficient. Nothing else we need to look at. If it is communicated, that is sufficient.
R8.
But I think in the connected appeal that exhibits.
In
are
both the
not-
appeals, one and the same.
Common record.
Common records.
Common
Yes.
record.
Only the exhibits are-
Give it. Either. Order sheet. They have not sent the exhibit. It contains check slip, order sheet, petition, written statement, issues, judgment, brief notes.
Certified copy.
You have
Yes,
the.
certified copy.
Please pass on. Or maybe something else is there in the other case?
In the other case.
Look at the next one. That's the only one.
Your Lordship would find at the bottom, my lords, the RPAD receipt at the bottom. This was sent, dated 24/7/2018. It was sent on 7/8/2018.
When is the check dated?
The accident occurred on 28/9, it is 19/12/2018. Much before that it was sent.
No,
my
no, no.
lords.
Accident 19/2. Check.
19/12, my lords.
19/12. Check.
21/6/2018.
21/6.
2018.
2018. When it was dishonored?
No evidence in that respect.
My lords, it was dishonored on. You produced the
It is on
bank statement.
24/7. Check dishonored on 24/7.
24/7 is the notice.
Notice. You can say and so. Returned as uncleared for the reasons funds insufficient. Whatever, they have sent it by 24.
Yes.
24/7/2018. Notice is sent. No, where do you get you can't call this as a acknowledgement.
This is the.
It is only to show you have sent.
I have sent, my lords.
We have to have, where is the acknowledgement?
My lords, it was sent, my lords, my humble submission is, the receipt which is produced along with Exhibit R8 would indicate the notice regarding the cancellation of policy was sent on 7/8/2008.
Settled law. It is not about sending, it is about receipt of the same.
My lords,
There
I have judgments. I would
There are
take.
judgments, I have also passed.
Yes, my
Recent
lords.
judgment also there is.
No, my lords, here the owner very much appeared before the court and he was represented all along. He never contested said anything before the court saying that he had not received a notice at all. Yes.
That burden lies on you.
Yes, my lords.
To elicit. No, what prevented you from filing the acknowledgement?
My lord, acknowledgement, insurance.
No, I'll tell you. You have sent a notice on 24/7. You must have received this acknowledgement by the time this trial is going on.
My lords, probably insurance company might have not received back the acknowledgement, my lords.
Then you should
What I would do is, if I go to the postal department, definitely they will, on a website, there would be details whether this notice was served or not, my lords. That would be there, my lords. That is one thing. And
No, that's as far as the liability is concerned, that's the crux of the issue.
yes, my lords, but still I would take your lordship to the certain decisions of this honorable court, my lords.
There are judgments of the Supreme Court.
Yes, my lord, judgment of the Supreme Court also, I would take your lordship to that. I would pass on this, my lords.
Take it. I have also passed several orders.
Yes, my lords.
And the view that I have taken is this: if the dishonor of the check is intimated to the owner of the vehicle, then there is no liability to the insurance company, and you have to file the acknowledgement before the court to show that it is received on the owner of the vehicle.
My lords, my submission is, we have sent him a notice. Owner was very much before the tribunal.
I think the
Yes.
notice is not sufficient. It is
No, that receipt also we have produced. I cannot get the
all
receipt.
the notices we send, not necessarily that they will be served on the person.
My lords, that notice,
Please
it is for
come.
the, for the owner to say that he has not received or what has happened.
Between you and him,
Yes.
because that is
Yes,
the owner.
yes, my lords.
In majority of the cases, the owners won't contest.
The first judgment, my lords.
Then we will say pay and recover.
No, my
Because
lords.
it is not contested. National
My
Insurance
lords,
Company versus Seema Malhotra.
Yes, my lords. G, alphabet G, my lords, at the bottom. At the bottom, my lords.
Which page?
Same first page only, my
No,
lords.
let's not go to the head notes.
Yes,
Straight away
the
come to
detailed portion is at paragraph number 17, my lords.
Yes.
in a contract of insurance, when insured gives a check towards the payment of premium, part of the premium, such a contract consists of reciprocal promise. The drawer of the check promises the insurer that the check on presentation would be the amount in cash. It cannot be forgotten that a check is a bill of exchange drawn on a specified.
Judgment do not deal with this situation. Next judgment.
Huh?
This judgment do not deal with this scenario.
Yes, next matter, next judgment, my lords. Rather, I would take the third judgment, my lord. This is passed by this honorable court. Paragraph number 7, my lords. 6 and 7.
Yes.
6 and 7, my lords. If we pursue the evidence given by RW 1 and 2, it becomes clear second respondent issued a check for obtaining a policy for vehicle bearing registration number so and so. The evidence of RW 2 shows the check was not honored because of want of funds. Second respondent. The dishonored check is produced before the court as per Exhibit R2. The intimation was issued to second respondent by letter dated so and so as per Exhibit R4. If we pursue the entire evidence of RW1 and RW2, it becomes very clear that the second respondent issued a check for obtaining a policy for offending vehicle bearing number so and so. Merely because a typographical mistake has crept in the intimation letter sent by appellant insurance company intimating the cancellation of policy, the tribunal should not have taken the opinion that cancellation intimation letters pertains to another policy. It may be stated here that if the second respondent has issued.
We'll have it on Thursday. I have passed orders because this particular aspect was
My
not
lord,
considered by the division.
My lord,
Relying on a judgment of the Supreme Court, I passed several orders on the similar point. What is the case if the acknowledgement is filed? What is the case if the acknowledgement is not filed?
But here
then what is the consequences of the owner not contesting the matter?
I would just, owner all along he was there.
Yes.
My lords, kindly your lordship may look into the finding of the tribunal. All along, I cannot be, I have said, I have placed some material before the tribunal saying that I have sent a notice to the owner and there is a due intimation. Owner was very much present before the tribunal, but he didn't say whether he got it or not. In the absence of that, I cannot be fastened with the liability, my lords.
It is your responsibility of the insurance company to
Yes, when the owner doesn't turn up, my lords. Here, owner was very much before the tribunal, my lords.
Your part, because you said I've sent. It's your duty to show that I've completed my part of my responsibility is completed. This is the acknowledgement he received. That is your responsibility. Unless and until you discharge it, you cannot say that I have no liability. That's a settled law.
Your lordship may kindly have it next week. By that time, I'll cross check from the insurance company whether what has happened to the acknowledgement, my lords. About 10 days time may be given, my lords.
17.
17 or 18th, my lords. By that time, I'll get the
18th.
instructions from
Yes,
them.
next matter.
Much obliged.
Number 19.
Yes.
Ravi Shankar CR for appellant.
Respond in this case, Lord.
Syed Abdul Sabur.
Claimant appeal. Claimant appeal for enhancement, your lordship. Say no insurance. Lordship.
Come to the table.
You have examined the doctor. In spite of the doctor evidence, they are not awarded a future loss of income, your lordship.
Where is that discussion? Why the court has not awarded future loss of income?
Discussion, your lordship, discussion is
Come towards permanent disability.
lordship, towards expenses.
Page number 14 and 15.
Medical record technician in specialist hospital.
Please.
And Mohan, G. Mohan is the doctor.
The doctor who was treated was not examined before the court.
Dr. G.
Another
Mohan.
doctor was examined.
Dr. Mohan Vijay as PwC, medical legal consultant.
Yes, sir. Is examined. There is a.
Why not doctor?
Because we have taken the summons also and they have not come prepared to before the court.
So you can examine anybody.
Because he is having a urinary problem. That is, the doctor has been assessed before the tribunal and also
It's your
affidavit has been.
it's a duty of the claimant to adduce sufficient necessary evidence before the court.
Correct, your lordship.
That you have not adduced.
Documents also produced, and also doctor has given the opinion on he has suffered the fracture of, kindly see I will read out the doctor evidence.
Difficulty is appearing for the insurance company.
Correct,
And
Your
appearing,
Lordship.
appearing for the enhancement. All these submissions, next state will come in your way.
No, not like that, Your Lordship, because we examined I will read out the doctor evidence, and Your Lordship can decide what
He's
is
a legal consultant.
legal consultant, but he is a doctor, Your Lordship. He is
What
not
is his
working as a medical legal
What is his
consultant at Specialist
qualification?
Hospital of Bangalore.
What is his qualification?
But his qualification is RTA, but he has not stated about the qualification. He said, I examined the injured patient, so and so, and also I state that the patient is alleged RTA at HRBR signal, and so and so. Patient was initially treated at the above said hospital. Patient sustained
First of all, court wants to know what is the competency of the doctor to depose before the court and to assess the disability. That I want to know.
Pardon.
The competency of the doctor to assess the disability and to depose before the court.
He has given the disability, he has only urinary problem. Kindly see the doctor evidence is
You
the
didn't answer
tenderness.
my question. I'm asking what is his qualification and what is his capacity, is how he can consider, how he can assess the disability. That we should know. Every doctor cannot come before the court and say that this is a disability. If it is a particular problem, it's a urinary issue. Some urologists should say that. What is the difficulty? What are the problems? Yes. So that is one account. On that count, we will not enhance. Next, any other thing?
Like opportunity should be given to the examine again. Opportunity should be given to the claimant to examine the doctor as per the lordship.
Yes. Next, any other ground?
That is one ground. That is the main ground for remand of the matter to give the opportunity to lead the examine the doctor.
Will remand the matter.
If not sufficient opportunity was given, 3 witnesses have been examined, including claimant. Another 2 witnesses have been examined. Despite of that, my lord, he has chosen to examine some other doctor. That is one aspect of the matter. The second aspect of the matter is, my lord, lordship may kindly see he has deposed before the court that he was earning 14,000 rupees per month, and it was not disturbed. Subsequently, even assume for a moment, my lord, if the injury, my lord, sustained by him, in any moment, my lord, if he is, my lord, the earning is affected, then my lord, the question will definitely arose. My lord, there is a, my lord, possibility of.
What is the occupation?
Occupation mechanic.
Mechanic.
He sustained the fracture of shaft right femur.
Nothing on record.
Shaft right femur.
That's not
with
necessary.
displacement.
But first of all, what is the disability? What is the impact of that on his future earning? That has to be considered.
Kindly see the order sheet. There is the order sheet. Sufficient opportunity was given. Summons were taken. It is the duty of cast upon the claimant to produce and.
Which year is this?
My lord, accident took my lord in the year 2015.
No, this is dated 2023.
Appeal is 23.
Date of order is 2023.
Yes, Your Lordship.
The accident my lord 2015. 10 years over.
2015 accident, 2018 MVC.
Please.
No, Your Lordship. Judgment is 23 only.
The petition has filed this petition.
18. It is 18. Not a
26,
15.
2015 is the accident.
Please.
Please come. Agreed with the award passed in MVC number 7325/2015, dated 9 January 2023. The claimant is before this court seeking enhancement of the compensation. When counsel appearing for the claimant submits that the tribunal had not considered the disability, though they have adduced the evidence. Hence, the compensation needs to be. His claimant is not the. What did you say? What did you write? A compensation needs to be enhanced. Then counsel submits that he has examined the doctor as PW3, who is a medical legal consultant at Specialist Hospital. As per the wound certificate, the claimant sustains swelling, tenderness with restricted movements and deformity over the right thigh region. In spite of the same, the court has not considered the accounts for the respondents of insurance, the accounts for the respondent owner of the vehicle submits that the court had rightly considered has given enough opportunity. In spite of the same, the claimant had not examined the doctor who is competent to consider the disability. Next, having heard the counsels on either side, there is a material on record. According to the claimant, he has sustained permanent disability. He has the claimant has examined PW2 medical record technician in specialist hospital and got marked document exhibit P15 to 22. And he has examined Dr. Mohan, who is a medical legal consultant. In the entire examination, it's not forthcoming. What is the specialization of the doctor and how he is competent to give the disability? Why was the treated doctor not examined? Nothing is forthcoming. In those circumstances, the court had rightly considered and not awarded any compensation at the head of future disability, future loss of income due to disability, as claimant has visibly failed to prove the same. In these circumstances, this court do not find any reasons to interfere. Accordingly dismissed. Next.
Lashik.
Cell number 10.
Other rates is necessary for the Lashik. Other rates has been not awarded. Remanded.
What is that?
It is remanded.
Remanded. I have dismissed it.
Lashik.
Cell number
Other rates
10.
is necessary to award other.
But you were not arguing on that.
Because you have said this one I will. Lashik. Other rates is also there. Lashik. Kindly see.
Then other than that, you please tell.
Other rates is awarded you Lashik. 30,000 pain and suffering.
1 minute.
Yes.
Where is the table?
Page number 16, your Lordship.
What are the injuries?
Injuries, fracture of femur, right region, and the X-ray shows the middle right femur and displacement of the overriding fracture of fragment. Femur.
Yes.
And
40,000
urinary
will
problem, your Lordship.
Then medical expenses as it is. How many days he was in hospital?
3 days.
Huh?
3 days.
There was food and nourishment. Court already granted enough for 2 days. The court had granted 12,100.
Lordship.
12,100 is granted for 2 days.
Towards conveyance and other things, your Lordship. 2,100.
Put together, we are granting as per the days 1,000 per day.
And amenities also lesser.
No, here
Yes.
already for your 2 days or 3 days, court has granted 13,000.
And taken treatment because he is urinary problems. That's the problem, your Lordship. That is because kindly see the doctor evidence. That is the.
For the attendant, nourishment and transport.
He has not attending the duty for 2.5 months.
That is a different aspect.
Yes.
How many days he was in a hospital is the only criteria for
One for
granting
the
it.
he has
That
taken
is
the
when he is in 3 days. Why did the court grant 12,100?
10,000 for conveyance because he is in the this one the Hebbal. He has come to the hospital and he is in the
That's
care
not
for
the criteria. If that's the case, in every case, we have to independently
because
do
you
that
can see the
exercise.
medical expenses of 1,25,000 he has spent.
Oh, he was in hospital for how many days?
What,
3
days?
He is in 3 days. Court has already granted, or which year is the accident? 2015. 2015, the amount is, as per the table, it is 12,500. Court granted 28,000. There is no enhancement is required in this.
And
Loss of future earning, anyhow, I'm not going into that.
Amenities,
when once that is not 10, that's why 10,000 is reasonable.
Amenities.
So,
And
will not interfere in anything.
Well,
except
pain and suffering, your Lordship.
What a month, another 10,000. And 10,000 towards legal expenses. Where is that? She left. Should ask her, no. Ask her to stay back. Like just low with regard to the on the other heads. as considering the injuries that are sustained by the claimant under the head of pain and suffering. This code is granting 40,000. Medical expenses, food and nourishment, conveyance, loss of income during the treatment period, quoted, and amenities quoted granted reasonable amount. This court do not feel any grounds to enhance the same. In the light of the so-and-so legal expenses to 10,000. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 2,04,832 to 2,24,832. The enhanced amount shall carry 6% interest. Partly allowed. Yes, next.
Cell number 20.
I am for claimant in the serial number 20, my lord.
I am for appellant, my lord.
20.2 and 20.3. I am ready, my lord, to argue them.
Insurance company challenging on the ground, my lord. Liability. As on data point, there is no DL, my lord. That's maybe pain recovery order, ma'am.
Charge sheet is filed.
Appending my vehicle itself, my lord. The charge sheet 3-1 charge sheet has been filed. 3-1 class charge sheet has been filed. Please, my lord.
So please tell the court, MFA 3660 of 2023 is arising out of?
Arising out of MVC 1347 of 2021.
1347 of 21.
Please, ma'am.
Then 20.1
20.1
is arising out of the same MVC?
No, different
Yes.
MVC.
What is the number?
That one is 1448 of 21.
48 of 2021.
48 of
Then next 20.2 arising out of MVC?
3.38 arising out of
No, you're getting confused. MFA 3538 of 2023 is arising out of?
yes, my lord. It is arising out of MVC 1347 of 21.
Yours?
Mine is the 3.38 of
3620 3620 MVC 1448 up to 2021.
In both the cases, you're on the same ground.
Same ground,
But they're not having the driving
no
license.
DL.
And charge sheet is filed under the 3-1 of the Red with Motor Vehicles Act.
Please, my lord.
The court, yes. Then coming to the compensation. First come to.
My lord,
Yes.
page 23 liability, my lord. The fact that the offending vehicle was insured with the respondent to is not disputed. The insurance policy was valid so and so.
That's
The
why I
alleged
asked you
accident
to
occurred
come for
on
the, please argue on enhancement.
yes. The accident took place in the year 2021, but the tribunal has taken table is 21, page 21, inner page.
Page?
Inner page 21, madam.
21.
Yes. In both the table, it is 21 page.
Both case 21 serial, page number
It
20.
appears to be paragraph number 28.
21 and 20.
Please, my lord, paragraph
Yes.
28.
My lord, the income taken is 15,000 instead of 15,500. madam.
Pain and suffering. Only one fracture,
Yeah.
40,000. How many days he was in hospital?
She was 6 days.
Huh?
6 days, 6 days.
Court has
She was
granted.
inpatient for 6 days.
Court has granted how much amount? Nourishment 15,000 adequately granted. Your appeal is there.
Insurance company appeal seeking
So
claimant
how many days he was in hospital?
6 days, my lord.
So we will make it 6,000.
Please, my lord.
Yes, relating to medical bills,
Medical bills, same, my lord.
89,000.
89,000. madam.
May be retained.
89,000.
Data period only 15,000 1 month.
Loss of earning, how many, he was there in hospital for how many days you said? 6 days.
6 days, my lord.
She was
Loss
for
of during
6
later
days.
period. Which year is the accident?
2021, my lord.
2021.
15,000 wanted to be.
Court had taken how much?
Court taken
15,000 only.
15,000 only consider, ma'am.
Court had taken 15,000.
Please, ma'am.
Then if that is the case, then you will not, there won't be any difference in future loss of earning. Yes, Mr. Counsel.
15,500 it has to be taken.
Huh?
15,500 to be taken, madam, instead of 15,000.
Why? You said it is 2021 accident.
Yes, madam.
2021
15,000.
As per notional income, it should be 15,500.
6/11/2021 date of accident.
Then it is 611 is 15,000 only. 2022 is 15,500.
Yes.
So
Yes,
what about the disability?
Disability 31. Doctor assessed 30%, my lord.
30% to the limb or the whole body?
Particular limb, my lord.
No,
Then
10% is
35%. 35% doctor has assessed. But the tribunal has taken 10%. It should be 12%, my lord.
11.6 will take 12.
11%, ma'am.
Huh?
11.5 something.
12%.
11.6.
Please.
So
12%, my lord.
15,000 into 12. What is the multiplier?
17, my lord.
17.
17.
Into 12. 12 by 100. Into 12 into 17. 12.
3,67,200.
67,000.
Please, my lord.
200. Yes. Damages. 25. Then loss of amenities, what is granted?
Loss of harmony is 15,000 rupees.
We will take another 10,000.
Please, my lord.
Pain and suffering 40,000 only.
Already awarded. It's coming to 5,82,200. What is the rate of interest?
6%, my lord.
4,80,000. Please come. Agreed with the award passed in MVC number 1347 of 2021, dated what about the owner? Is he served? Served. Across Pasha for R2. Where is the council?
Yes, my lord.
Afroz Pasha.
Agreed with award passed in MVC number 1347 of 2021, dated 4th February 2023, whereby the tribunal had awarded compensation of an amount of rupees 4,80,000 and fixed a liability on the owner of the vehicle. Both the insurance company as well as the claimant are before this court. The claimant's appeal is MFA number 3538 of 2023, and the claimant's appeal is MFA number 3538 of 23, and the insurance company's appeal is MFA 3660 of 2023. The tribunal had fixed a liability on the insurance company, and counsel appearing for the insurance company submits that the driver of the offending vehicle was not having a valid driving license. The charge sheet is filed against the driver under section
31 charge.
All the IPC sections also you tell?
Section 331 class 1 are written with 181 of MV Act.
Section 3(1) read with section 181 of the Motor Vehicles Act. What are the IPC provisions?
IPC provision.
Act along with the IPC provisions. It is his contention you are recording. It is submitted that it is submitted that which clearly shows that the driver is not having a valid driving license. Hence the principle of pay and recover will apply, and the insurance company is pay and recover will apply. And the court had, but the court had failed to consider the same. It is submitted that when it comes to the compensation, when the claimant was in hospital for a period of the 6 days, court had granted an amount of rupees 15,000, which is on the higher side. Next para. Land counsel appearing for the claimant submits that court had failed to grant reasonable compensation on all the grounds, and on all the grounds the court ought to have considered the income at 15,000. Court has considered at what? 15,000.
15th national income tax.
Then don't take that. It is submitted that the court had failed to grant reasonable amount under the head of loss of earning during the later period, considering the injuries, and even for the loss of amenities also, the amount that is awarded is a meager amount. When the doctor had opined that the disability is assessed at 35% of the whole body, court ought to have taken 12% to 35% to the limb. Court should have taken 12% to the whole body, but the court had taken 10%. Hence, on these counts, the compensation needs to be enhanced. Next para. Having other counsels on either side, material on record. First, coming to the contention of the insurance company with regard to the applying the principle of pay and recover, considering the charge sheet, and whereas the provisions under which they are charged clearly shows that the driver of the offending vehicle is not having a valid driving license. Hence, in the light of the law laid down in Swaran Singh's case, the principle of pay and recover will apply, and the insurance company is liable to pay the compensation and record the same from the owner of the vehicle. Next para. Land counsel appearing for the respondent, not respondent, the land counsel appearing for the claimants. Then coming to the enhance in this, the owner is but the wakalat is filed with the advocate. There is no representation on behalf of the owner of the vehicle. Next, coming to the enhancement, considering one fracture injury that is sustained under the head of pain and suffering, this code is granting 40,000. Considering the fact that he is in hospital for 6 days under the head of attendant and nourishment, this court is reducing the amount from 15,000 to 6,000. Medical expenses and loss of medical expenses, court had rightly taken at 89,000. When it comes to loss of earning in the later period, this court is granting for 3 months 45,000. Future loss of income, the court ought to have taken the disability at 12%, as 1/3 of 35% has to be taken, which comes to 11.6, and 12 ought to have been taken. 15,000 into 12 into 17 into 12 by 100 is 3,67,200. Considering the disability of 12% for under the head of loss of amenities, this code is granting 25,000. In the light of the law laid down in make laws, so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 5,82,200. Accordingly, appeal of the insurance company is partly allowed by holding that the principle of pay and recover will apply, and insurance company shall pay the amount to the claimant and record the same from the owner of the vehicle. The appeal of the claimant is partly allowed, enhancing the compensation from 4,80,000 to 5,82,200. The enhanced amount shall carry 6% interest. Then the amount in deposit shall be forthwith transferred to the court. Yes. Next two matters. 20.2 and 20.3. Yes, what about this?
Yeah, my lord,
Your
but,
ground is the same.
Same, my
Also, yeah. Please come to. This is 1357 again.
MVC 1448 up to 2021.
357.
1448.
MVC 1448.
Huh?
MVC
1448.
1448.
3620.
3620.
Both are connected. 360 and
Yes.
yes. Please come to the table.
Treatment,
So-
1,25,500. Huh?
1 minute. Pain and suffering. What are the injuries?
Injury, only left humerus fracture committed right
Lower limb.
ulna fracture committed on left clavicle fracture.
Huh?
Clavicle left upper limb.
How many fractures? One.
One.
Then 40,000 reasonably granted. No enhancement. Then loss of what? How many days was in hospital?
6 days in this also 6 days, my lord.
This also 6 days.
Please, my lord.
6 days.
Laid up period. 15,000 into 3 save. Will grant 45,000. Then attended nourishment. 6 days was in hospital.
6 days in
Court has granted.
court granted, my lord. So food and nourishment attendance charges will
15,000
10,000 rupees.
So we are granting 6,000 attendant,
ma'am.
nourishment, transport. Yes, next.
Loss of amenities 10,000 rupees. as well.
What is the disability in this?
Disability doctor assessment 25% particular limb.
Medical expenses 1,25,500.
Doctor assessed particular limb 25%. Court has considered MACT 8%. One side has been
25.
corrected. Please, ma'am.
8.3. 8 reasonably considered. So no enhancement on that. Amount is also considered at 15,000. So loss of earning on account of disability 2,59,200. Damages for pain. That's all. Loss of amenities. Another 5,000.
Please, ma'am.
Legal expenses. So, what is enhanced is only here loss of earning during later period. Court had granted 15. This court had granted 45. So that is 30,000 is enhanced.
Please, ma'am.
And somewhere it is reduced.
Reduced food and nourishment attendance charge for 6 days inpatient 10,000 rupees. In that 4,000 rupees
You
reduction.
will calculate instead of making it complicated. It comes to 5,07,000 rupees. 700. Please come. There is no enhance. 4,59,000 it is.
4,59,700 is granted by the tribunal.
So there is no enhancement. Except because of the legal expenses it has come. If we remove this 10,000, it comes to 4,90,000. Oh, it is 4,59,000. Yes. Agreed with the award passed in MDC number 1448/2021. Both the insurance company and the claimant are before this court. Claimant's appeal is MFA number 3575/2023 and the insurance company's appeal is MFA number 362/2023. Then counsel appearing for the insurance company, same contentions with regard to the insurance company. Same contention, his contention only I'll record. Then counsel submits that on all the counts, the compensation that is awarded by the tribunal is not just on this number. Then coming to the insurance company's thing, same as it is in that. Now coming to this, the court had under all the heads, the court had the court under all the heads has granted a reasonable amount. But when it comes to loss of earning during the later period, the court had granted 15,000 and considering the fact that considering the injuries sustained, this court is granting 15 into 3, 45,000. Then loss of amenities the court had granted 10,000, considering the disability of 8%.
8%.
This court is granting 15,000. On all other counts, when it comes to the attendant and nourishment charges, when he is in hospital, court had granted 15,000. This court is reducing the same to 6,000. So on all the counts, the claimant is hence on other counts, the amount that is awarded to the court is reasonable. Accordingly, the appeal of the in the legal expenses that make a versus so and so 10,000. In the view of the same, the claimant is entitled for an amount of rupees 5,700,000. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 4,59,700 to 5,700,000. The enhanced promotional carries 6% interest. The appeal of the insurance company is partly allowed. Same in the other case. Amount in deposit also shall be forfeit. Yes.
Depository amount may be transferred to MACT.
MACT.
In? Not necessary that. A memo in 20.1, a memo is filed seeking dispensation of notice to R1. Same is dispensed with at the risk of appellant. In 20.1, Mr. B. Pradeep is directed to take notice and he shall file the wakalat within 1 week from today. Then in all of that, yeah. Yes, next.
Cell number 21.
Paper the respondent.
Jwala Kumar.
Ready, madam. Pain requirement may be added.
Where is he?
Yes.
Short point. And before the tribunal, my lord, only on point of liability, the owner of the lorry produced a fake driving license at the time of investigation. After judgment, an insurance company came to know that it was a fake driving license. For that, I have produced additional documents.
Where is the owner of the vehicle?
He's served. Where
is the document?
That, my lord, along with the application.
But somebody has to be examined in this regard. That it's a fake certificate, fake document. How can we decide here?
Remind the matter of it, get it examined and.
Agreed with the award passed in MSC number 2689 of 2022. The insurance company is before this court questioning the award on the ground that the driver of the offending vehicle has produced, the owner of the offending vehicle has produced the fake driving license, and after the disposal of the case, they came to know that the said driving license is a fake license. As such, the insurance company is not liable to pay the compensation. When counsel appearing for the respondent submits that even that way, the principle of pay and recover will apply. This court, without examining the concern, this court cannot give a finding that the said document is the driving license that is placed before the court is a fake document. Hence, considering the application that's filed before this court deems it appropriate to pass the following order. Order date so and so is set aside on the limited issue of whether the driving license that is produced is a genuine document or not. On that, both the parties shall adduce necessary evidence. The insurance company shall adduce the necessary evidence as before this court, though notice is served on the owner of the vehicle. He has not filed he has not appeared before the court. The insurance company shall, without further notice, shall appear before the tribunal on 22nd of September and shall adduce the evidence with regard to this, and the court shall decide the same within a period of 1 month from the date of receipt of the copy of the order. Yes.
Amount in deposit.
No. Amount in deposit shall be forthwith transferred to the court, and the same shall be deposited in a fixed deposit. Yes.
Records should be remitted.
Everything will go.
Much.
Yes.
P. Mahadev Swami for appellant.
Paper.
You are representing whom? Why time? This is the one argued matter.
No, ma'am. This is first time matter.
List is matter. Give some other date. at the request of and counsel for the respondent insurance company. Yes, 23.
22-9.
What of-
Cell number 23. Cell number 23.
Yes.
Okay, Prasanna Shetty.
My appeal is for enhancement, my lords, and insurance appeal is for contributory negligence.
I have not contributed negligence and the quantum, both are.
And the quantum also. Contributory negligence, what is your stand?
The the injured man was riding a scooty.
Shall we read that particular finding on this?
Yes, ma'am.
Page number.
But parrot minutes, 2 minutes is the brief facts minute. When the petitioner was going towards Kunchabailo along with Anushri,
Charge sheet is filed against whom?
charge sheet is filed against me, ma'am.
Driver of the offending vehicle.
Driver of the
What
offending.
is the other evidence that is adduced by you to take a contra view by this court?
Ma'am, there is no evidence adduced. But only man's point is this, ma'am.
You are relying on a sketch. Relying on a sketch,
Yes,
the charge sheet is filed.
Yes, yes.
Now, charge sheet has to be considered and the sketch has to be.
I will point out minutes from the facts minutes. The here minutes she was overtaking minutes. The injured was overtaking along with a pillion rider. Mine is a bus minutes. She was overtaking in the city. Minutes, a duty was cast on the minutes. The rider of the motorcycle or the scooty. That minutes she could have overtaken the bus if only minutes there was sufficient space to overtake and minutes there was no minutes she had taken all precautions.
Whose case that she is overtaking?
That their case minutes that after.
The case of the petition.
Please me. 1 minute here in
Going towards.
Otherwise
along with
confused.
So and so. Reached near so and so at the time.
It
the
is
bus
not in
was
dispute that much she was overtaking the vehicle.
The driver of the bus showed signal to the
Yes,
petitioner.
that is what.
Overtake the bus.
That is their case. Yes, ma'am. No, ma'am, my
How do you disprove it?
my only contention is
Have
this.
you examined the driver?
No, ma'am, we have not examined.
So let's leave that ground. Please come to the point.
Minutes. For that minutes, I am relying on a minutes decision of this court minutes. If I may minutes
Take
pass
that.
on.
Judgment has to be applied to the facts. of the
Yes,
case.
I understand, minutes, your lordships. Kindly minutes, third to minutes, page number, paragraph number 27 minutes, page 12 of 18.
20?
27 minutes.
Yes.
But so far as the contributory negligence is concerned, all that is required is claimant should have failed to take reasonable care for his own safety. A person is guilty of contributory negligence if he ought reasonably to have foreseen that if he did not act as a reasonable, prudent man, he might hurt himself, and in his reckonings, he must take into account the possibility of others being careless. The responsible, careful driver does not always assume that the other users of the road, whether drives or others, will behave with reasonable care, and he guards against the negligence of others when experience shows such negligence should be
Yes, Mr. Counsel.
common.
Your
But
driver
here-
will say,
Yes.
give a signal that you please go forward. There is a space.
Yes.
He tells you.
Yes,
It is your own driver gives the signal.
that is their version, minutes. What I am saying is this, minutes.
Where is your version?
No,
Who is
there is no,
examining?
we have not examined minutes. There is no dispute with regard to that minutes. Kindly see minutes now, the para 30 minutes, if I may read.
Yes.
It is true that the corporation has minutes. In this case also, it's a bus as well as in this case, instant case, which I am relying on. It is true that the corporation has not taken the plea of contributory negligence, but does not prevent the court or the tribunal to hold.
Where are you reading?
I am reading minutes para 30. Para 30.
Para 30
Yes,
says
Lord.
during the cross examination.
I am reading minutes from the judgment minutes, what I have just
For
handed.
this one.
Yes, minutes.
Yes.
It is true that the corporation has not taken the plea of contributory negligence, but does not prevent the court or the tribunal to hold. So, when things speaks for themselves, leading to an inference about it, in the absence, in the case of Sharda by so and so, coordinate bench of this court has also held that contributory negligence can be and very often is interfered from the evidence adduced already on the claimant's behalf or from the prospective facts either admitted or found established on a balance of probabilities in the case.
Yes.
31 minutes. Further, in my opinion, in the present case, the magazine res ipsa liquidator can be applied because it is admitted by the claimants, appellant themselves, that when the bus has suddenly stopped, the motorcyclist who was coming behind the bus could not control the vehicle and thereby dashed against the bus. So according to me, to some extent at least, motorcyclist has also attributed for the accident, and as such, I respectfully disagree with the view expressed by my learned senior brother that the fault for the accident entirely lies with the driver of the bus alone, as in my opinion, the deceased and the driver of the bus have contributed to an extent of 25% and 75% respectively for the accident. Therefore, in my view, on issue number 1 and 2 framed by the tribunal or recorded accordingly, para 33. Since there is divergence, in this case, 3 judges have 2 divergent view. Therefore, it was referred to a third bench. In this case, what I am reading, para 33. Since there is divergence in our opinion, office is directed to place the matter before the Honorable Chief Justice and obtain appropriate orders to pose the appeal before the third judge for opinion. The Lordship may kindly come to para 39.
Yes.
Learned counsel for the appellants, claimants appellants urged that the tribunal was in error in holding that the accident in question had taken place on account of rational driving of the motorcycle by the deceased. The tribunal had according to the appellants failed to appreciate that the accident had occurred entirely due to sudden application of brakes by the driver of the bus in the middle of the road without giving any signal to the motorcycle coming behind the bus. It was further contended that the plea of contributory negligence ought to be raised by the corporation at the appellate stage was futile in the absence of any such plea. Having been raised in the objections filed on behalf of the corporation, it was urged that since the bus was going at high speed, the deceased motorcyclist driving behind it reasonably expected that in the event of driver intending to stop the bus, would give a signal to that effect so that the motorcyclist would take proper evasive action to prevent crashing into the bus. No such signal having been given, and the expectation of the motorcyclist about what the driver would do in the normal course having been belied, the resultant accident could not be attributed to the deceased. The non-examination of the driver of the bus as a witness was also, according to the appellants, a significant circumstance which would show that the sudden stoppage of the bus in the middle of the road was wholly unjustified. On behalf of the respondent corporation, it was on the other hand argued that the deceased who was following the bus on the motorcycle was under an obligation to maintain a safe distance from the bus going ahead of him to ensure that in the event of the bus being stopped suddenly, the motorcyclist do not crash into it. That was according to the respondent corporation, even otherwise a well-recognized rule applicable to the vehicular traffic on the roads, in as much as the accident had occurred on account of the failure of the part of the motorcycle to maintain safe distance from the bus and his inability to control the motorcycle when the bus driver applied the brakes. The accident could not be said to have been caused by any rash and negligent drive of the act of the driver. It is submitted that even when a plea of contributory negligence had not been taken in the objections filed on behalf of the corporation, the tribunal could, upon proper appreciation of the evidence adduced by the parties, record a finding whether or not, and if so, to what extent had the drivers of the two vehicles contributed to the occurrence of the accident. The fact that the motorcyclist coming from behind had failed to maintain safe distance and had thereby failed to act as a prudent man placed in his position would have acted necessarily implied that the motorcyclist had also contributed to the occurrence of the accident in an equal measure. It's para 41 minutes. I will read minutes after 5 lines. It is common ground that the objections filed by the respondent corporation.
All that you are reading, that it cannot be
But
applied
here
to the facts of the case. It cannot be unless and until you come up with some evidence. We can't apply
But
the
here
law in isolation. It has to be.
Here the admitted fact is that the rider of the motorcycle was overtaking the bus.
You should have examined the driver saying that I have not signaled. She only overtook without, though there was no proper space for her to overtake the bus. Nothing. Charge sheet is filed against your driver.
Charge sheet is filed against.
No, at least you should examine the driver to say, to dispel their contention.
I am only saying that the event speak for itself. That there was an overtake by a motorcycle.
We are governed by the evidence.
Yes.
The evidence on record do not disturb. We will not assume and presume things unless and until you prove something. Now this law, we are not disputing on the law. Law has to be applied to this, which will not apply to the facts of the case. Yes, please come to the
That's on the point of quantum.
table. Come to page 39, para 39.
On the quantum, the
Pain and agony, how many days he was in hospital?
Well, it's 55 days, my lord.
55 days.
Huh?
55 days.
55.
But only one fracture injury.
Yes,
Only
my
one,
lords. Nearly to the amputation of left hand, my lords. I am producing the recent photographs of the claimant, my lords. These are the recent photographs of the claimant. Doctor has advised, my lords, 72% disability to the limb. The tribunal has taken 45%. That is also on the basis, my lords, under the head marriage prospectus, no compensation has been awarded. Including that, my lords, the tribunal has taken 45%, which is, my lord, mentioned
45% to the body.
Whole body. At page number 42, my lords, paragraph 38.
So now under the head of pain and suffering.
Now CW1 evidence. CW1 evidence, who is doctor, now says it is true to say that the fracture is united, not it is what we have elicited. Further, what we have elicited, it is true to suggest that the disability mentioned in the disability certificate is pertaining to only one limb. I am not aware that if the disability issued by me is compared to whole body, it will be 1/3. Not, she does not say that. Firstly, she admits that the fracture is united, and she says, I am not aware that if the disability is issued by me compared to the whole body, will be 1/3. She doesn't say what is the whole body disability, and he says that I am not aware. If it is compared to the whole body, it will be 1/3. Therefore, 72% what is given is to the only particular limb, it's not to the whole body. Therefore, if 1/3 is applied, it will be 24% as against 45%.
How can it be 72% to the whole body?
No,
even let us take looking at the injuries, looking at the photographs you have placed.
Yes,
it is a disability to the limb, not to the body.
Yes, trial court has taken 45% to the whole body, including the marriage prospectus. At para 38.
52% according to the doctor.
Yes, my lords. It comes to 24%, my lords.
So, taking 24%, let us loss of future income is 18,000.
18,000, my lords.
That I am disputing, because in her own claim petition, she says my salary is 15,000.
Where is it?
It's in the claim petition itself.
Then how can it?
My lords, in claim petition, it is mentioned at 15,000. In evidence, she told that I was getting 15,000, but at the time of leaving the job, I used to get 18,000 rupees, and she has examined the proprietor also.
Who stopped you from saying it in your claim petition?
Who
stopped you from saying that you earn 18,000?
Yes, I have also examined the PW2, who is the proprietor, employer.
Why you did not say? It's the first question. Did your employer brought any records to show, except giving evidence, any other material?
No, she has received, my lords. To that effect, my lords, I am producing on case law, my lords, wherein, my lords, it is stated that in this case, my lords, only salary slip was given, no author was examined.
And that too in a particular facts where you have already stated in your claim petition.
Yes, but yes, my lords.
Like him, you also want to read your judgment. I have no objection, but I will not take.
But in my evidence, my lords, I also stated that I was getting 15,000, but at the time of leaving, I used to get 18,000, and I examined the proprietor.
When did you file your claim petition? After leaving the job or before leaving the job?
After leaving the job.
So we will take 15,000. So loss of future income, 15,000. So this disability is
24%, my lords.
So why not future prospects?
Future prospect is.
So 15,000. What is the age?
Age was 26 years, my lords, at the time of accident.
So 40% future prospects. It comes to 6,000. 21,000. So 21,000 into 12, what's the multiplier?
17 will be
minutes.
the multiplier.
Into 24. It comes to 10,28,160. What was awarded by the tribunal?
16,52,400 is awarded.
So there itself your appeal will go.
Yes, ma'am.
Loss of amenities 50,000. That is also a good amount. So now instead of calculating all this, we'll say that there are no grounds in your appeal. Both appeals will go now.
Please, ma'am.
Please come.
Interest is awarded 9%.
That we will reduce.
Yes.
Agreed with award passed in MSC number 302 of 2020 dated 23rd November 2022, whereby the tribunal has awarded compensation of an amount of rupees 21,15,330. Both the claimant as well as the insurance company is before this court. The claim petition is filed seeking compensation of an amount of rupees 30 lakhs for the injuries sustained by the claimant in the accident. It is a case of the claimant that on 29/6/2019 at 5:40 p.m. when he was going to his going on his scooter, when he reached near Government School, at the time the bus which was going in front of the scooty, the driver of the bus showed signal to the petitioner, to the claimant, to overtake the bus and go forward. That as soon the petitioner tried to overtake the bus, the driver of the bus increased the speed of the bus and took slight right turn, which hit the mirror of the scooty in which the claimant was proceeding. Due to the impact, the claimant and the pillion rider fell down and sustained injuries. The tribunal has held that the accident and the charge sheet is filed against the driver of the bus, and the court has held that the accident had taken place because of the rash and negligent driving of the driver of the bus. And when it comes to the compensation, court has awarded the compensation as per the table given below at paragraph number 39 extracted. And counsel appearing for the insurance company submits that there is a contributory negligence on the part of the claimant. The court had failed to consider the same. It is submitted that when looking at the sketch, looking at the width of the road, where there was no space, the rider of the scooty, that's a claimant, had overtaken the bus. Had the rider been careful, the accident wouldn't have happened. As such, there is contributory negligence, and this aspect was not considered by the court. He had relied on the division bench judgment of this court in case of Srimanti versus Krishna Deva Madiwal, reported in laws Karnataka 2004-6-37, and he particularly relied on paragraphs. Paragraph
25, 27.
He relied on paragraph 25, 27, paragraph number 30, and then
31.
31.
And my lords, 40. 42, my lords, 48.
42, 48.
Yes.
Relying on this, it is submitted that there is contributory negligence on the part of the claimant, and the court had failed to consider the same and apportion the same on the claimant. Next, having heard the counsels on this, it is submitted with the learned counsel that even the compensation that is awarded by the tribunal is on the higher side. Next, having heard the counsels on either side, perusal material on record. First of all, coming to the submission that there is contributory negligence on the part of the claimant, for that no evidence is used by both the parties. It is submitted that there is a contributory negligence. No evidence is adduced by the insurance company. The charge sheet is filed against the driver of the bus. The evidence of the claimant is that the driver has signaled her to overtake the bus, and later he took a right turn. If the insurance company is disproving the same, he should have established the same by way of adducing some evidence, and admittedly, there is no evidence. There is no dispute about the law that is laid down in the above referred judgments, but the same has to be applied to the facts of the case. And that judgment do not apply to the facts of the present case, where the insurance company has failed to discharge the burden cast upon them. Hence, in that view of the matter, this court is of the view that the accident had taken place because of the rash and negligent driving of the driver of the bus, and there is no contributory negligence on the part of the claimant. Then coming to the enhancement, this court has perused the table wherein the court had granted, tribunal had granted an amount of rupees 21,15,330. Looking at the same, there are no grounds to interfere with the same, and the court had rightly considered and granted. Hence, accordingly, the appeal of the claimant is dismissed, and the appeal of the insurance company is also dismissed. The amount in deposit shall be forthwith transferred to the court.
There will be reduction in the
Interest into the insurance company.
the other
partly allowed.
I'm sorry, the future income lots will get reduced. 16 lakhs.
No, that's why I said I'll dismiss both your appeals.
Lordships, if your lordships are taking the disability at 24%, that will work out to 10 lakh 28,160. There will be reduction. 16 lakhs 52,000 is granted.
That's why I said that you kept quiet.
No, I'm sorry, I did not get your lordship.
That's why I said I'll dismiss both your appeals.
I'm sorry, I did not get your lordship.
It will be a substantial reduction.
Please, my lord.
The compensation.
Then, my lord,
So then we'll do pain and agony. We'll reduce by another 20,000. We'll enhance by 20,000. Medical expenses.
under the head food, nourishment and convenience
That's
charges,
what.
my lords,
Hmm.
55,000, sorry.
That's what. Food, how many days you are in hospital?
55 days inpatient, my lords.
We will split that. Attendant and nourishment.
No, my lords. Under that, my lords, I have already produced 70,000 rupees. The travel slips, my lords, amounting to 70,000. Including that, my lords, only 22,000 has been given under the head food, nourishment and convenience. At
How much? What is the amount? 70.
70,000, my lords. At page number 38, my lords. Exhibit P62 to P81 is the traveling bills, my lords, amounting to rupees 70,000.
We'll grant 1 lakh under that count.
Let's.
Because it is like 55 days.
Yes, ma'am.
Generally, on all the three heads,
Yes.
we grant 55,000. You are saying that you have spent 70,000.
Traveling
So
bill,
for the
only traveling bills.
only
ma'am.
traveling for the
Yes.
remaining heads.
Yes. If per day 1,000 is also taken, my lords.
1,000 is for all. All the three heads is 1,000. That's what we are granting.
Yes, ma'am.
So 1 lakh. Loss of income during laid up period. This we will enhance. 15,000 to 5.
75.
75,000. Then what is his age?
26 years, my lords.
Loss of marriage
Marriage.
prospects. One lakh. Loss of amenities. 55,000. So loss of future income. I said 15,000. We'll take 15,000. This
It will come to 10 lakh 28,160, ma'am.
10 lakh.
28,160.
We have to. It's coming to 6,000. 21,000 into, what is that? 12 into?
12 into 17 into 24%.
24.
Ten lakh 28,160.
Then my lords, under the head marriage prospectus, my lords.
Also granted 1 lakh. It's coming to 16 lakhs. So something is covered. 16 lakh 93,090 against 21 lakh 15,330. Then counsel for the respond insurance company's contentions. He submits that when it is evidence of the claimant that when it is a case of the claimant that he is earning 15,000 and at the time of evidence it is stated that he is earning 18,000.
18,000. I've examined the employer PW2 also.
The court had considered that income. When the evidence is that he is earning 15,000, when it is his case, why such a statement is made in the claim petition? Nothing is forthcoming. It is submitted that the court ought not to have taken 18,000 as income, and even under the other heads also, the amount that is awarded by the tribunal is on the higher side. Next one, having heard so and so, at the head of pain and agony, considering the hospitalization and the injuries that are sustained, this court is granting 1 lakh. Medical expenses as it is, food, attendant and nourishment 1 lakh. Loss of income during the later period, 15,000 into 5, 75,000. Loss of marriage prospects 1 lakh. Loss of amenities 75,000. Legal expense in the light of the law, loss of future income. Taking income at 15,000, 40% future prospects will come to 6,000. That is 21,000 into 12 into 17 into 24 by 100 is 10 lakh 28,160. And the light of the law laid down in so and so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 16 lakh 93,090. Accordingly, the appeal of the claimant is dismissed, and the appeal of the insurance company is partly allowed by reducing the compensation from
10 lakh rupees, 10,000 rupees litigation
expenses is given from an amount of rupees 16 lakh 90 from an amount of rupees 21 lakh 15,330 to 16 lakh 93,090. The entire amount shall carry 6% interest. The amount in deposit shall be forced to transfer. Yes, next list.
List number 2, serial number 1. List number 2, serial number 1. Central
Thursday matter, madam. Matter listed on Thursday. The maintenance concern reduced to 20,000 to 10,000. The husband.
That's what I asked you. You wanted to get instructions.
That's for 10,000. For time being, we are ready for 10,000.
It can be.
Lordship, it is too exorbitant regarding she herself left out the matrimonial house without intimation to the husband and also without to the wife house, matrimonial house, and also she is residing separately, and also destroy my life at this stage. After lapse of 5 years, she has filed the maintenance petition before this honorable court. Your Honor. The honorable trial court below has erroneously passed the order without consider the contention taken by the respondent, Your Honor. Being agreed by the said order, I prefer the above petition before this honorable court on this various grounds, my lordship. Because she is not entitled for the any relief as per law, my lord, because under section 125 subclass 4 of CRPC, my lord. No wife is entitled for any relief.
Where is it decided that she has decided?
She is residing separately, my lord.
That
and also she is doing the adulterous life with someone.
It has to be proved.
It is a matter of trial, my lord.
125 CRPC proceedings will not decide all this.
It is purely.
Have you filed an MC?
Lordship, I have I'm not seeking any, filed any petition for divorce till today. Further, my lord, on the ground of this, only seeking the relief of a man, only money minded, Your Honor. Accordingly, if she is ready, I am accepting my family. Otherwise, she is not ready. She left out the house. It is okay, my lord. Without any grounds, she is not entitled for any maintenance, my lord.
Yes.
Because of she's she is residing separately, my lord. Kindly turn the page number 26, my lord. 23, my lord, which she has already executed the indemnity bond, which I produced at page number 20, ink page number 22.
What indemnity bond?
What happened, my lord? When the marriage is arranged by her parents, she's not interested to marry the petitioner, my lord. After she have some affair with someone person. After marriage, she left out only residing limited period, my lord, in my house. Therefore, after marriage, she is not residing permanently after lifetime. So she is presently also residing in other persons. So how can I bear this maintenance to her, my lord? It is purely matter of law, my lord. As per 125 subclass 4 is very clearly settled principles apply. This correctly says that, my lord. My lord, as per law, no wife shall be entitled to receive any allowance for the maintenance or interim maintenance and expenses of the proceedings, as the case may be from the husband under this section, if she is living adultery or if without any sufficient reason she refused to live with her husband. So, my lord, is very settled principles
Yes.
of.
What is your income?
I'm being the agriculturist, my lord, and also I'm doing coolie also. There is no sufficient, there is no regular income. The trial court passed an order of the interim maintenance of 20,000 per month, which is too exorbitant, Your Honor. Therefore, kindly set aside this order and also kindly remand back to the press consultation.
With respect to the adultery is concerned,
No, don't go into
evidence
all
is
that.
required. Evidence is
About the
required.
income.
Income of the already stated, my lord, is the cab driver. Is the cab driver. Number 2, the agriculture properties are in the name of his father, and after his death, the properties are transferred into the name of his wife, his mother. And in all, 2 acres 32, about 3 acres of land situated in around the Devanandi city. And apart from that, around the agricultural income is more than 24,000. I've stated
24,000
per month. Only in respect of agriculture properties concerned and cab driver. They are seeking for only 20,000 to your wife and children, wife and one child. Now he's studying 4th standard.
Yes, please come. Agreed with the orders passed in I number 2 in criminal miscellaneous number 888 of 2022, dated 2nd September 2023, whereby the court had granted 20,000 as maintenance to the wife and the child. The husband is before this court, and counsel appearing for the husband submits that the wife is not entitled for maintenance as she has deserted the husband and she is living in adultery. It is submitted that the husband is ready to take back his wife, take back his wife, and 125(4), it's very clear that a wife who is living in adultery and desertion and who has deserted the husband is not entitled for any maintenance. It is submitted that he is doing agriculture and he is not having sufficient income, and in spite of the same, the court had granted 20,000 as maintenance, and the same needs to be set aside. His contention is twofold. One is that the wife is not entitled for maintenance, and even if she is entitled, she is not entitled for an amount. The amount of 20,000 that is granted is exorbitant. Next paragraph. When counsel appearing for the respondent, wife submits that the husband is having the father of the husband is having agriculture properties. His income per month is 24,000. He is working as a cab driver and is earning enough income. It is submitted that the wife is earning how much?
Wife is not.
I'm presently, no, my lord, I'm not a cab driver. I'm before.
Contention. That is his contention.
Wife
That
is
I have to
not-
record.
Wife is not earning, my lord. She is presently residing with her parents.
It is submitted that the wife has to take care of the child who is aged,
Now the 11 years.
who is aged 11 years. And it's the responsibility of the husband to take care of the wife and the child. In response to that, land counsel, the petitioner submits that he is only an agriculturist and he is not in a position to pay an amount of 20,000. That is exorbitant. Having heard the counsel, sorry, the said there is a material on record. The first submission of the counsel with regard to the fact that the wife is not entitled for maintenance as she has deserted the husband and she is living in adultery. Both these aspects cannot be considered by this court in an application that is filed seeking interim maintenance. Admittedly, no MC is filed by the parties and there is no pronouncement by any of the court that the wife is either living in adultery or she has deserted the husband. In these circumstances, the court can only look at whether what is entitlement of the wife and what should be the appropriate amount. There is no dispute about the fact that he is having landed properties. According to the husband, those properties are in the name of property belongs to the father. According to the respondent, the petitioner will succeed to the said properties. And according to the petitioner, is working as an agriculturist. This court has perused the order of the family court, wherein the court has observed that the husband has filed his affidavit of disclosure of assets and liabilities, that he resides in his native place working as a coolie. It is stated that his mother is his dependent, is incurring 4,000 to 5,000 per month. His monthly income is shown as 10,000 and is working as a private company and drawing month. And according to him, the wife is working in a private company and drawing monthly salary of 15,000, but has not mentioned the employer of the wife. Hence, the court had considered the judgment of the apex court in Rasheed versus Neha, and considering the status of the parties' income earning capacity of the husband, had directed the husband to pay 20,000 and one-time litigation expenses 10,000. According to the wife, she is unemployed, and according to the husband, she is working. Considering the fact that considering the fact that he is working as an agriculture coolie, and the fact that he is having several properties, his father is having the agriculture properties, which in the joint name, or which he will succeed to. Further, the wife is taking care of the child. The amount of 10,000 would be an appropriate amount, considering the facts and circumstances of the case. In that view of the matter, this court is setting aside the order dated so and so. This court is modifying the order dated so and reducing the maintenance amount from an amount of rupees 20,000 to 10,000 accordingly.
For orders matter, serial number 2, Kumar MN. Serial number 2.
What is this?
My lords, praying 2 weeks time.
What 2 weeks?
My lords, we didn't get a respondent number 2 address. Respondent 2 number
2 weeks
address.
time is granted to do the needful. By the time if the needful is not done, the petition shall stand dismissed without further reference to the court. Now in this, it's a writ petition of 2022. Even to issue notice to R1 and R2, why? What is the difficulty?
My lords, we get only a respondent number 1 address we got. My lords,
Who is who?
2 is a wife. Wife, my lords.
One is?
1 is husband, my lords.
And who are you?
Union of India.
Union of
Petition.
What is the writ petition by the Union of India?
My lords, it's about.
What is this writ petition? Let's see what's the relief that you are seeking in a family court matter. Let's see the relief. Issue a writ of certiorari certifying the order dated, passed in MC number. What is this writ petition?
My lords, I am not aware of the facts.
So how can this court set aside an order passed in MC Directed to pay joint sum of so and so. Where is that? No, first of all, the writ petition is not maintainable. How can this court pass any order on a MC? How can this court pass, set aside the order? Please come. The present writ petition is filed.
Maybe list tomorrow.
Tomorrow. It can't, how this matter is pending before the court from 22. Yes, 3.
So in the last date of hearing, they have received copies of IA, my lord.
Petitioner, my lord. Senior is inconvenient, my lord. 2 weeks time.
Whereas in the last date of hearing, it is posted for dismissal, my lord. Every day they are saying same reason and taking adjournment.
No, my lord.
List this
Senior was
matter
inconvenient.
heard the and counts for the respondent in part. List this matter as part heard on give a date. Yes, next.
17-9.
Yes, next 4.
Cell number 4.
List after service of notice to the
Cell
respondent.
number 5.
Interim order if any, extend. 5.
Cell number 5.
5, I am for the respondent, my lord. This is the writ petition, my lord. It is a family court matter.
She is the petitioner.
I am the petitioner.
Yes.
This is a case where, my lord, no maintenance has been granted by the court, and the reasons are very vague. What has been stated? Your lordship, may kindly come to the order, my lord.
What is this IA for vacating stay? What is stay?
He has filed for vacating. This is stay because they are proceeding with the matter without deciding on the maintenance, rejecting the maintenance. So I have come before this court that let the maintenance be granted first, then let the evidence be commenced. So I have taken a stay here.
Which year is the MC?
My lord.
Which year is the MC?
Which
MC is of which year?
MC, this is of my lord 2023 years. GNWC, this is.
GNWC of 2023.
23.
When did you file the IA?
I filed in 22, my lord. Sorry, IA is filed. 14th. I filed immediately.
Who filed the GNWC?
My lord.
GNWC is filed by whom?
By him, by the other side, my
So
lord.
now it has to be stayed. Because he has filed, it has to be stayed.
Yes, my lord, it is stayed by this honorable court.
But how can you seek such a relief of staying the proceedings?
Because they are proceeding for the evidence.
Will it be decided within that time?
No, no. In this case, my lord, the parents have filed GPA, not the boy. The respondent is in UK. The parents have filed the GNWC case. They want to lead the evidence. Your lordship may kindly see the atrocious behavior. He files first a restitution case.
Not go into that. What is that impugn order? Please.
Impugn order. Your lordship may kindly see it is unreasonable. Page 15, my lord. Page 15.
First of all, come to the cause title of the GNWC.
Yes, my lord. That is at page, your lordship may kindly see page 14.
Page
14, my lord.
No. I'm asking about the cause title in the main petition.
Order sheet, I was very well. That
Cause
was,
title in the petition that
yes,
is.
yes, your lordship may kindly see page 12 of Annexure B, my lord. Shri Charles Bryan, represented by SPA.
Running page number.
Page number 18, my lord, if I'm not wrong. 19, my lord. Page number 19, Annexure B.
Charles
Bryan,
represented by SPA holder Sri
Chinnappan.
Father. Son of Chinnappan V, aged about 72 years. It is filed by the grandparents. Representing the son. Where is son?
Son is in UK since 2019. He has not come to India and not visited the child also. Just because, my lord, we asked for maintenance, they said we will file GNWC and take custody of the child.
No. Let's see, if this GNWC is filed in the year 2023 by them.
Yes.
When did you enter appearance?
When did
you enter appearance?
Immediately, my lord, after the notice was served on me.
Which year?
Same year, my lord. Within a month.
Where is your IA?
My IA is, your lordship may kindly see. I have produced IA. Page 33, my lord.
A number 3.
33, my lord, page.
3 and 4. What are these 3 and 4? Interim custody of the minor son has filed IA number 5. So you are questioning IA number 5.
5.
Rupees 1 lakh per month for their child. What do you do?
My lord, I'm working, I'm earning around, my assets and liabilities I have produced at page 47, my
But
lord.
tell what is the income?
I'm earning, I'm taking 74,599 per month, my lord.
What is husband's income?
8 lakhs, my lord, per month.
8 lakhs? As
In
per the
UK,
US.
in UK, he's taking in pounds.
So what would be the parity of it?
Parity is 8 lakhs. There he's getting around in
No,
pounds.
you
my
just
lord.
can't simply, we can't convert it like that.
Yes,
There is a standard for that.
it has to be, my lord, it has to be converted for a reason, my lord. It is in form of a pounds, my lord.
It is in form of a pound.
Yes, my lord.
There is a table how it has to be taken. How you have to now, you have to look at the cost of living and
Yes, yes.
everything.
E-
And
even-
after, as it is, you can't say that it is 8 lakhs, convert into 100. We can't say
My
it
lord,
is 8 lakhs.
yes, my lord. Even after deducting all the deductions, what he has
Not
produced.
deductions, there is some, there is a table.
Take away
for
money.
that.
My lord, he,
Take away, there is a, what is the money pad, something, some table is there. As per that, it won't come as it is like 8 lakhs.
it is, my lord. I'll submit because they have not even filed assets and liabilities before GNWC code when I filed for maintenance. In MC case, they've go and filed the GNWC. They filed assets and liabilities, which I can produce it. Your lordship may kindly see the amount. He has purchased a house, he has purchased a car.
What is the age of the child?
Child is now 7 years, my lord.
Let's see.
It's born, my lord. Shall I pass on the assets and liabilities, my lord?
Not necessary.
The child is born, my lord, on 14/8/2017, my lord.
What is this finding of the court? Because other petitions are finding that she is not entitled for maintenance under the GNWC. In in this
Yes, my
petition.
lord. Under they have provoked the section 12 of the Guardian and Wards Act 1890, my lord. It will provide only the interim custody of the child, my lord, not the maintenance. Not the maintenance, my lord. And they have filed an application in the MC petition for the maintenance, my lord.
Is it
in the
granted?
MC in the MC case?
Is it granted?
Still, no, my lord. Order is pending, my lord.
Anyhow,
In
let
15
this
days,
court, will this court will grant in this.
15 days, the order is
What is the
reserved.
income of the father?
Now at present he is not having any income, my lord. He has
Then
been
why he wants
terminated.
custody?
He has been terminated from the job, my lord.
Why he wants custody? How we will take care of the child?
The custody means he will come and he is seriously searching for the job to come here and maintain the.
Where is the material in that regard that he lost his job?
Yes, my lord. I will.
Please come.
Next year date, I will
Agree
submit the
with the
termination letter.
order passed in I number 5 and GNWC number 403 of 2023 dated 14/10. What is the date of the order?
On
And my lord, writ petition is not maintainable, my lord. Here.
Why?
Because there is in the Special Family Court Act, they have to come with an MFA, my lord.
14/10, my lord. 14/10/24.
14/10?
24, my lord.
14/10/2024, whereby the court had dismissed an IA number 5 filed by the mother seeking interim maintenance for the child is dismissed. The mother is before this court. When counsel appearing for the mother submits that the father has filed the GNWC, the grandfather has filed the GNWC representing the father. It is submitted that the father is residing in the UK and earning sufficiently. Mother's take-home salary is 75,000 and she has to take care of the child who is 6 years old. When an application for maintenance is filed before the court, court has failed to consider the same and the grounds on which it is dismissed is that there are other petitions pending and there the maintenance is sought and that can be considered in those petitions. It is submitted that that cannot be the ground for the court to dismiss the petition. It is submitted that the father has a responsibility to take care of the child and at any point of time he has he has failed to contribute for the maintenance and welfare of the child, the family court ought to have decided the same and passed appropriate orders for the child's maintenance. Land counsel appearing for the respondent submits that against the order impugned, the petitioner has to file a MFA, but not a writ petition. It is submitted that under section, when an application is filed under section 12 of the Guardianship and Wards Act, there cannot be an application seeking for maintenance, and court can only order interim custody of the child. It is submitted that on these counts, the petition that is filed itself is not maintainable, and considering the fact that the other petitions are pending, the court had rightly dismissed the petition, and there are no grounds to interfere. Next paragraph. Having heard the counsels on either side, there is a material on record. Both the contentions of the counsel for the respondent husband have no legs to stand against an interlocutory order that is passed by the family court. Only a writ petition lies to this court, and there is hence the petition that is filed is as well maintainable. Then coming to the submission that in a petition that's filed under section 12 of the JNWC Act, there cannot be interim maintenance. That is settled law. That in those the family court is very much has the jurisdiction to decide to consider and grant the maintenance. Then coming to the order impugned, the reasons that are stated by the court for dismissing the application as far as the for the child's the maintenance is concerned, it is contrary to law and to the facts. The court, just because the other petitions are pending and admittedly where no maintenance is awarded, court cannot dismiss the application on that ground. Accordingly, the order impugned is set aside and the matter is remanded to back to the child family court. The parties shall appear before the family court on 24th of September, and within 1 month from 24th, the court shall dispose of the IA. IA number 5.
The respondent may be also directed to appear, my lord. Because the father and mother, because they are GP holder, they will come.
Whoever is the GP holder, he will appear. No, I will not say that the father has to appear.
Very good.
Yes. Next.
Cell number 6, adjourned. Cell number 7, preliminary hearing B group. Preliminary hearing.
Yes.
Please, let's file a petition challenging an impugned order passed on 15/5/2025, in which the court has ordered 8,000 maintenance per month to respondent. My lords, my income is 10,000 to 11,500. My lords, if your lordship may kindly go to page number 48.
Where is it absorbed by the court?
Lords, page number 40. Lords, the respondents allege that I am doing a granite business, but in fact, the petition.
Your statement of assets and liability.
My lords,
as per that, how much is the income?
My lords, I haven't filed assets and liabilities. My lords, I have filed my objections and I haven't filed the objections.
Why you didn't file?
My lords, the sufficient opposition has not been granted in the trial court. My lords.
Notice will not interfere with this order. No.
My lords, stay may be granted in this case. My lords, will file assets and liabilities in the next hearing. My lords, kindly directions may be given to
The respondent petition is permitted to take out hand summons on the counsel appearing for the respondent and file a memo to that effect. Once a memo is filed, is the matter. Yes, next.
Cell number 8.
Yes.
Trial court has ordered 30,000 maintenance and 40,000 towards litigation
How much?
expenses. 30,000 per month, man.
Let's see the order. Where is the operative portion?
Operative portion is at page number 35, my lords.
35.
35. And on the date of the application, I was earning 40,000. As
The
on today,
petitioner husband is directed to pay interim maintenance of 30,000 per month to respondent wife and a minor daughter from the date of application. Pay some more rupees 40,000 towards litigation. Where is your income discussed by the court?
income is at page number 41, my lords, page number 33, the previous page, my lords.
On the contrary, even though the petitioner treats the para 41 and his monthly expenditure is so and so, freelance accountant,
Please, my lords.
credit of lakhs together amount to his 3 SB accounts. He has not chosen to produce his bank statements for a period of 3 years in respect of those 3 accounts. Why?
So by oversight, there was a mistake.
No. We will
lords.
make it very sure that.
Only one observation, my lords. Page number 130, my lords. Page
No,
number
it's not 130. When as per the judgment of Rashish.
Please, my lords.
When you have to file 3 years bank statements, why you didn't file? So, no, the court has granted. We will also draw that adverse inference
I agree,
and we'll confirm this order.
My lords. Page number 130, my lords, for one minute, my lords.
For what purpose?
My lords, she has filed her assets and liabilities where she has declared that she has 1 kg of gold, 28 kgs of silver in her possession.
So why she will, every day she will sell that and
No,
she
no,
will
my
have
lords.
it.
The petition is of desertion, my lords. They were not living toward, since,
Here on the point of maintenance, why the order that is granted by the court is not correct. Now, the court has drawn an adverse inference, whether the court can draw or not. It can draw because you have failed to place the document.
small interim relief, my lords. I'll submit the bank statements.
No, you shouldn't. Why should you submit it before the court when enough opportunity is given? We will not go ahead with the matters like this. Now it has become a routine procedure for everyone not to file the statement of assets. Whatever interim order is passed, come to this court and question. Then again, time pass for some time here. And that the matters be pending before the trial court. This court would do 1 exercise. They will do 10 exercises.
If I wanted to, my lord, avoid this, my lord, I would have not declared, my lords.
Huh?
If I wanted to avoid that, my lord, I would have not declared my
Because
assets.
your client is represented by an advocate, and advocate do know that what is to be filed along with the statement of assets and liabilities. Ignorance of law, we can't. That's not an excuse.
All interim relief, my lords, please, my lords, sir.
Every day, I'm looking at the orders. Every day, I can't interfere with every order where there is failure on your part.
All indulgence, my lord. I have one opportunity.
What indulgence? Why should we indulge? Maximum this 40,000 as litigation expenses is granted, that I will stay. This 30,000 I'll not stay. You please let the other side come. Let other side say what is their case. The order land counsel submits that when his income itself is 40,000, the court had granted 30,000 as maintenance and 40,000 towards one-time litigation expenses. It is submitted that when his salary itself is 40,000, court had granted 30,000, which is unreasonable. This court has perused the order. In the order, the there is a finding that as per his affidavit of assets and liabilities, he has got credit of lakhs together amount in his 3 SP accounts, but he has failed to place those bank statements for the past 3 years in respect of those 3 accounts. Considering that, the court had granted 30,000 maintenance. The Honorable Apex Court in Rashish versus Neha has clearly, in the judgment, it is clearly stipulated that what are the documents that has to be filed along with the statement of assets and liabilities. And if a party fails to place any of those documents, an adverse inference has to be drawn. Then counsel submits that by advertence that is not filed, this court is not inclined to consider the same. Hence, as far as the maintenance amount is concerned, this court is not inclined to interfere. However, they shall be stayed as far as paying of 40,000 is concerned. Till the next date of hearing, the petitioner is permitted to take out hand summons on the counsel appearing for the respondent. Shall a memo to that effect? Once the memo is filed, this is the matter.
Please,
yes, 9.
9. Arya Devanand.
Lord, it is not the case of maintenance is at issue.
Why notice is not ordered? You are here.
My lords, we check the.
Yes.
We'll file wakalat, my lords, and objections.
What is it?
Lord, kindly be at annexure. Kindly be at annexure.
Huh?
This is a dispute with regard to.
Let me first see what's the impugned order.
Impugned order is for having deprived the husband of 3
Page
days
number.
custody.
Page number.
Page annexure F and F in ink page 61. The portion of the order F. Attachment order is issued. Committing default in the matter of handing over the custody of the child for 3 days.
It is permitted to engage the services of the counsel. You are for the mother or the father?
Mother. And kindly go to.
What is the date of order? When is
the date of the order is 22/6/2024.
What is the order?
The order is there is an act of disobedience on my part, and therefore there shall be an attachment order with regard to the property owned by the petitioner and as well the salary to the extent of 3,000 rupees per day, every day default till the date which she hands over the child. In fact, in between those days, after these 3 days, there was no consistent default at all. In fact, in order to demonstrate that, joint memo was filed by both the parties at Annexure G.
No, there is already an order passed stating that there is a default on part of the,
Only for 3 days.
where is that?
That is what it is. Kindly go to our application part, IA. IA filed in regard to this, paragraph 9, on ink page 55. On basis of this IA, order came to be passed. Ink page 55, paragraph 9, the last one sentence running in that paragraph. Left-hand side column, 55. Due to the said act of JDR number 1 was deprived the custody of my child for a period of 4 days from 15/4/24 to till 18/4/2024, resulting in passing of this order.
Why? Why you have not obeyed the order of the court?
Please, the reason is, kindly go to, my child is suffering from epilepsy by birth. And kindly go to, in order to demonstrate that, kindly go to annexure Annexure C at page 43, the report of the doctor, which this court called for on the writ side. In page 43.
Whatever it is, now there is an order passed. For because of this reason, you do not want to give the custody of the child, your remedy is somewhere else, not in this petition. Now, there was a disobedience on the part of the mother. For those 4 days, why it was not handed over?
The reason is the child, in fact, can I draw my lord's attention to Annexure G?
Yes.
Where parties with good sense filed the memo jointly before the court. With good sense. Of course, we both mutually commit default either in the matter of you handing over the custody of the child or me returning the child back to you or on the due date. Anyway, henceforth, we will not do that. Annexure G, jointly signed by both the parties.
What is the page numbers? It's easy for the court to look at the page number.
65.
Yes.
And the typed version is at 60.
Joint memo is filed when? 9/7?
60. Immediately after the passing of that order.
Then, according to him, when is the disobedience? Dates are?
Dates are annexure, paragraph 9 on annexure 9, 4 days.
What are the dates?
4 days.
Order dated? No.
4 days as per the paragraph 9 of annexure G.
You are referring something at page 55.
65.
55.
Yes, 51, annexure E.
15/4/2024 till 18/4/2024. So when this IA is filed?
When 22/6/2024. Order is passed on the very same day.
22/6?
2024. Orders came to be passed on the very same day.
No, let's again go back to the joint memo.
Please, my lord.
Joint memo.
Joint memo. That is during the month of July.
What is this?
My lords,
we'll grant stay, then we'll see.
My lords, they absolutely have no bona fides to come before this honorable court. Your lordships had heard this matter at length and disposed it on 2nd of May 2025. Before your lordship, this matter was arising out of the same execution petition, and your lordships had directed that the executing court shall ensure that the compromise order is complied with after considering the objections, if any, by the judgment debtor, and accordingly a show cause notice was issued to show cause as to why her salary should not be attached. And 404 days of arrears of visitation rights, my lords. 404 days from the date of, my lords.
404 days, she has not shown the kit to you.
She has not. In fact, last weekend also.
Only 4 days.
That is his application.
Absolutely not, my lords. Since past more than 1.5 months, he has not even seen his child. We, at least as per the compromise decree, despite 404 days, as per compromise decree, at least Saturday, Sunday, we are to have the visitation. Even that she has not given. That is the reason why the attachment warrant was issued, and several observations to that regard. If the I am not sure if the execution case order sheet is produced, but there are observations made that she has
Do
not.
you have?
I do have.
Please pass.
Execution petition is filed.
Let's see.
Annexure D on page 45.
No, she's talking about the.
From
order
the
sheet.
date of passing of High Court order, my
let's see
lords.
this. Pass on that.
In the month of July, August, there are observations made by the court that she has not been complying with the compromise decree.
When is the order of this court?
My lords, it's on 2nd May 2025.
2nd May 2025. DHR and counsel present and file memo. JDR and counsel absent. Directed to produce certified copy of the orders by 24/4. DHR and counsel present, JDR absent. Advocate for JDR absent. Both the parties are directed to comply with the terms of the decree passed in view of the compromise petition. DHR and counsel present and produce a certified copy of the order passed by the High Court. Advocate for JDR absent. JDR present and praised time to file objections. Reporting that her counsel is hospitalized. Call on 3/6. The JDR is ready to comply the order of visitation rights and custody orders as per their compromise petition. The custody orders are supposed to be complied on Saturday and Sunday and also to pay the maintenance arrears, hence call on 9/6. DHR and JDR absent. Advocate for DHR and JDR present. Both parties have to file one memo with regard to their visitation and also so and so.
That is what the memo is
Both
filed.
advocates present. The advocate for DHR submitted JDR has complied the visitation rights on 14/6/2025 and 15/6/2025, 21/6 and 22/6. The JDR has not complied on 28/6/2025 and 29/6/2025, 5/7/2025 and 6/7/2025. The JDR submitted due to the exams and unit tests, the child is unable to attend the visitation. Both of them agreed to be present on along with the child. The child is also present before the court and child told that he will be having class test on Monday and Tuesday, and it is not every Monday. Therefore, there is no hurdle for visitation rights as per the earlier order. When there is a class test on Monday, can talk through phone with child and they can adjust with the visitation rights on careful perusal of the timetable for the test. The say of the JDR with regard to cancelling the visitation rights in view of the test of the child and scoring less marks does not arise and no modification can be made. JDR absent. And the advocate for DHR submitted that the JDR has not complied the visitation rights as on 19/7. The presence of JDR with regard to affidavit filed by the JDR. JDR and advocate for JDR. What is this conduct of the JDR?
Lord, in fact, on few occasions, of course, to be fair with the
Not
court.
few occasions. Let her come with, you file your objections. We will not suspend.
My lord, the attachment order is
Let
issued.
it be done.
Attachment, for the time being, it can be
I should
suspended.
be convinced. I am not convinced with this.
Very true,
conduct.
but till the next date of the hearing, it can be.
Counsel appearing for the petitioner submits that an attachment order is issued by the court only for non-complying the orders of the court on
It
3,
can
4
be
occasions.
till for a limited period, it can be
3, 4
suspended.
occasions. Because a person
My
who
lord,
takes the order
can
of
I,
the
can I
court.
proceed, my lord? Can I proceed, my lord?
Yes,
To,
do that.
to appreciate the fact that, the ward is suffering from epilepsy, she has to be subjected for medical test.
Did you on all these occasions, now I have seen the order sheet. Where is your
Look,
representation?
the Annexure F answers all these questions. Annexure F joint memo filed by both the parties answered that question.
After that is the proceedings.
Both the
which are
parties
being-
were put at rest. In fact, the good sense prevailed upon both the parties, of course. Then they filed a joint memo, my lord, till the next date.
To something which is which is After the joint memo. Even after filing the joint memo, she has failed to comply with.
No,
all
no,
the-
no, after the event which,
Look at it.
the event in respect of which attachment order was issued,
If you are
event at which in attachment order was,
That also, it shows the conduct
Look,
of the party.
no, the attachment order was issued in regard to an event.
You argue or somebody, you have a senior?
My lords, my colleague will argue.
I'll pass orders tomorrow, come tomorrow, we'll hear it and pass orders.
Great.
Not tomorrow.
Whatever did, but I'm not granting it tomorrow. If you're
No,
ready.
till a week's time, otherwise my salary will be attached, I'll be deprived of my salary to
I'll
maintain
pass
my
orders
child.
tomorrow. I'll pass orders tomorrow.
Milord, tomorrow, instead of tomorrow, can it be taken up 2-3 days later so that I can argue the matter? Until then, let them not proceed with the execution. That is what I said. Attachment order is issued. It has gone out of the court in this sense.
Want me to listen now itself and pass orders, I'm ready to pass orders. But I'm not convinced.
No, this is not a case where maintenance is at issue or a permanently is non-payment of it.
Anybody who has no respect to the orders of the court, this court cannot entertain.
Well, both, in fact, both. That is what the court observes.
You file the petition against them, we'll pass orders.
No, in
It doesn't
fact,
matter because they are disobedient. Both of you are doing it. Court has no sympathy for any of them. When you come to the court, when an order is
Milord,
passed, it's a duty to comply with the order.
Milord, there were instances on both the sides that there was a breach of the order. Annexure F, joint memo filed by both the parties will put at rest because of the good sense prevailed upon them.
But after that also, that sense is not shown in the order sheet where the party is not complying after that also.
Thereafter, no, it was, Milord, till a week's time, the order may be suspended, a date may be fixed so that I can argue.
The order passed.
Please, Milord.
No, the order passed.
21, I have actually 24. I have explained in my paragraph 21 of my writ petition.
Which year, which date?
Please, Milord.
24th of August.
Yeah, yes. At paragraph 21 may be looked into writ petition.
No, 24th of
I have
August.
given an account of as to why I did approach this court about few months of delay. I have given an account at paragraph 21, my lord. It is
Mr. Counsel, I'm not convinced with that.
till next week, my lord. Till next week.
My
Should there be an attachment order against me for attachment of my salary and my property?
Yes.
Should there be an order, my lord, for the simple reason?
List this matter on Thursday. Yes.
Till
So and so undertakes to file wakala.
Well, should there be an order of this kind in respect of attachment where I have committed a delay of?
So that the parties henceforth will not do anything.
My lords,
My
while
lord,
they have,
Can it be listed next week so that I can argue the matter at once and be done with the matter till the suspension of the order may be
my lords,
made,
while
my
they have
lord.
filed this petition, they have still not complied with the visits that we.
Yes.
Till it may be suspended till the next week, my lord. Till it may be suspended.
Pandurangan. Delete the name. Yes.
It may be suspended till then, my lord. For just a week, I am seeking an indulgence
So
of the
been
court.
waiting for 2 months, nothing has happened. So.
No, they have issued the attachment
They
order
should-
day
they
before
would-
yesterday. Day before yesterday, they have issued the attachment order.
Choice is yours, either on Thursday or next week, whatever you want.
My lord, Thursday would be a good day for me rather to come before the court and argue the matter because of some other personal inconvenience do I have from.
Monday, this is a matter on Monday.
My lord, till then it may be suspended, my lord, for till Monday. So that in case if this court upholds the order of the trial court, of course, the order will come into force and there will be attachment and all that will follow consequences. Till Monday, my lord, attachment order may be suspended.
That is not the subject of challenge, my lords.
Yes.
Cell number 10, Subba Reddy KN.
Yes.
Fill a petition for speedy disposal of my IA.
Which year is MC?
The MC is of 2003, my lords.
2000?
24, my lords. 24.
Which court?
My lords, this is a court before the Fifth Additional Family Judge, my lords, family court.
Why should there be an order for disposal of a 2024 petition?
My lords, I'll just peruse take your lordship's attentions to page number 20, my lords. That's a order dated 21/3/2025, my lords. I filed my IA number 3 of the for the maintenance and as well as the school fees which have to be paid to these on behalf of the students, children, my lords.
On disposal of IA number 3.
IA number 3.
Filed on when?
21/3/2025. 21/3/2025.
Yes, please come.
My lords, now, my lords, it's now only issue, my lords, I'm concerned before your lordships is that last year's school fees for both the children.
I number 3 is 5. Seeking maintenance oblique educational expenses of the child. Land Council submits that I number 3 is 5.
Page number 35 is IA.
21/3/2025. And so far no orders are passed by the court. Hence the present petition is filed seeking early disposal of the same. This court has already issued directions to the family courts to dispose of the all IAs concerning visitation and the maintenance within 1 month after service of notice on the other side. Considering the fact that this is passed, this is filed in the month of March, the family court shall decide the same within 1 month from the date of receipt of the copy of the order. Notice is not issued to the respondent.
May I make one submission, lords? The matter has been heard. The orders have been not passed for the past 2 months.
It is heard.
It is heard. It is completely heard, my
It is
lord.
submitted that the
I've
matter
sought for a prayer for a
heard
week. It will
and the
be
matter
disposed
is
of in a week.
reserved for the orders, and so far orders are not pronounced. The court shall pronounce the orders within 3 days from the date of receipt of the copy of the order.
Please, minutes.
Yes, next.
In B group, serial number 12, 11, Virupakshaya PH for petitioner. Virupakshaya.
Yes, give some other date.
Yes, 22.
Due to paucity of time, this court
Huh.
not able to hear the matter, list on some date.
22/9.
12.
Serial number 12, Manjunath NM.
Respond.
Ready, ma'am.
Yes, give some date. Yes, 13.
Interim order may be extended.
Term order earlier granted is extended. Yes, 13.
Serial number 13, Pratima SK.
Respondent.
They have given some proposal on the
I
last.
have given some.
Has no proposal at all. In fact, he's given judgment saying that why the respondent
I have
should
given a
not be, 1
proposal.
minute, should not be
I have given a
forced for
proposal, ma'am.
mediation. No party can be forced. There is only one proposal the entire thing has, that they're okay to.
Is it so?
Mediation, that I have said that I am not agreeable for mediation. I have given a proposal saying that I have an accommodation. You come there because there is serious POXO threat to the children. Serial number 16, there is another case which pertains to the same person. Here the question is whether the child, in fact,
I think I'll pass orders on the merits of it. Give the fact.
in fact, I have, in fact, I am filing one,
Will consider a repetition.
I am filing.
That because all this is old story. I've heard so many times.
No, your ladyship, there are 4 IAs pending of mine which I have filed seeking.
This is repetition. Is her
Yes, this writ petition has a bearing on all the other IAs which are pending
Where?
before the family court. There are 4 IAs which are pending. In
But
fact,
let us- no, the writ petition that is filed before this court has to decide it. I'm not concerned with what is pending before the trial.
no,
court.
the relief sought in this. I am
Let's see.
producing a document showing that where all the businesses are there, the brother who was also accused, charge sheeted, now he has been permitted to travel across India. Now, if the petitioner is also allowed to, then who's going to be responsible for the safety of the children?
You know that.
I am producing my affidavit on affidavit showing the
Impugned order is at
documents
136.
where all the businesses are there, what all the inquiries which are pending.
Yes.
136, my lords.
In fact, I had suggested even if they have any counter proposal.
I will just come to the operative portion, my lords. 145. There's only 3 lines that the court observes. It says that the children are with the mother, they are safe, all of that. The respondent is also educated person and she may take up job anywhere. And there is apprehension of the petitioner for shifting the child.
145.
My lords, 145, I'm so sorry. 145 ink page, my lords. Second line, the respondent is also educated person and she may take up job
I'm not
anywhere.
able to find that. It starts, the page starts with.
Well, it starts with also submitted in internal page 10.
145 starts with sexual harassment.
Well, impugned order, my lords.
You said for page number 145.
Yes, impugned order. Annexed J, my lords. J. It's a common order, in fact.
Yes.
May I, it is in fact para number 15, earlier it starts.
Yes, 145.
145. Well, second line, the respondent is also educated person
and she may take up job anywhere, and there is apprehension of the petitioner for shifting the child. That is all. Therefore, considering the facts of the case, issuance of direction to the respondent is necessary not to take the children out of the jurisdiction of the court till disposal of the petition. This is all that the court observes. Nothing else, no
Whatever you
reasoning
want
is
to
given.
File it in the section. We'll hear it on Thursday. This is a matter on Thursday.
Number 14, Vinayaka S. Pandit.
Great.
My lords, I appear for the petitioner husband, my lords.
Yes.
I have challenged the interim maintenance, my lords. 20,000 is what is granted, my lords.
20,000.
Yes, my lords.
Where is the respondent? Yes, give a date due to paucity of time. The matter cannot be taken. List so and so. Yes, 16.
Serial number 16, Chetan K.
Any date assigned, my lords?
Yes, they'll give the date. Yes.
On 12th, please. 12th.
Can your lordship take this
No,
matter up
12th
on
it's not possible. What is
17th
the
or
date?
19th? my lord?
18th.
17th or 19th?
18th, how many matters are there?
18th would be.
Please wait. Huh? 18th, give the date.
I'm grateful.
Yes,
Obliged.
List 3. Serial number 1, orders, Srinivas V.
A week's time.
My lord, needful has been done, my lord. With regards to payment of maintenance, my lord, there is no such order on 38, my lord.
Non-filing for having paid the, give that.
My lord,
Give
the
the
trial
order
court, the trial court has granted maintenance of 10,000, my lord. But the petitioner is a senior citizen.
When only time is granted to do the needful. Order is passed on 38/20/24.
Yes, my lord. On 38,
And across that the husband is retired employee and considering the submission of the answer, stay of all further proceeding pursuant to the order. Yes. Then counsel submits that the needful is done. List this matter after service of notice on the respondent.
interim order may be extended.
Earlier granted is extended. Yes.
Cell number
It is
2.
not a conditional order to extend every time. It said stay of all further proceeding. Yes, next.
Cell number 2. N Kumar,
Send this also positive of time. Give a date.
24/9.
Yes, 3.
Cell number 3.
Fair for petitioner. Madam, proposed petitioners are the wife,
Respondent
3
is not
children.
there. This also give a time.
24/9.
Yes, 4.
Cell number 4. Ganesh GG.
My lord's order on 27/2/2024 for the payment of the entire arrears of it has been done, my lords.
It is submitted that as per the order passed by this court, entire arrears are paid. List this matter. Give a date.
My lords, mediation may be referred, my lords.
Land council submits that. The matter may be referred to the mediation. Where they stay in Bangalore,
Bangalore.
the party shall appear before the mediation center in Bangalore. And appear before the Bangalore Mediation Center on 24th.
Please.
Inform the other side also.
Please.
Cell number 5.
For the
Yes,
petitioner in
for
this
the
matter,
respondent.
lords, the order has complied. To that effect, I am filing a memo along with the order sheet of the trial
And
court.
council submits that the order passed with,
Petition copy and document.
Process already paid, my lords.
The-
Summons is served.
it is submitted that you appear for the respondent.
Respondent.
Land council for the petitioner submits that the interim order passed by this court is complied with. Land council for the respondent submits that the papers are not served. Council for the petitioner serve the copy of the petition on the council for the respondent. List this matter in the month of October, give a date.
Oh.
Yes, 6.
Cell number 6.
Much of this.
Cell number 6.
I'm appearing for the respondent. Best time for objection.
For petitioner, my lord.
Yes, give a date.
Cell number 24/9.
Yes.
Cell number 7.
Give a date.
Satish Chandra.
Give a date. 8.
That is on 15/9.
Yes.
Cell number 8.
This also.
15/9.
This also. Yes, 9.
Cell number 9. Latif B.
Give a date. Same in all this, wherever date given, because of paucity of time, the court could not hear the matter. Yes.
17/9.
Yes, 10.
Cell number 10.
Other side.
Respondent is not there. You have a stay?
No, madam.
Same. This is also paucity of time. Next
22/9.
13.
22/9. Cell number 11.
Appear for the respondent.
SG
I have
Bhagwan.
filed an IA for vacating of interim order. my lord. That's
This matter list on Friday. 11th on Friday.
It's
not
12/9.
Friday, my lord. Thursday, my lord. Positive.
Thursday.
11/9.
Please.
Cell number 12 urgent. 13. Shriram Singh.
This also give a date, positive
Yes,
time.
ma'am.
14.
17/9. Cell number 14.
I am for petitioner, my lord.
Any urgency in this?
4 weeks time may be granted, madam.
Why there is an interim order in your favor?
Interim order may be extended.
Smarter, give some day in October.
Interim order may be extended, madam.
Yes.
Cell number
16.
15. 15 urgent. Cell number 16.
Yes.
BK Mohan.
Give a date.
Uh,
Give a date in November.
22/9.
Yes,
Cell number 17.
Yes.
Balakrishna MR.
This also.
17/9.
Look, all the matters wherever interim order is there, extend.
Yes.
Give a
Cell number
date.
18. Hemant Kumar.
I think they have moved the memo in this.
Yes, ma'am.
18, give a short date.
That is 15/9.
Uh,
Serial number 19
This also.
on 19/9.
25 matters, give a short date.
20 urgent.
No, I think both of them are apparent. So the 19 also, there's some long date in November.
October.
November now.
Yes, no, November. Serial number 20 disposed 21.
Correspondent minutes. I pray for time to file objection minutes.
Yes, this also long date.
November.
Look at it, stay.
Yes, ma'am.
Yes.
2022. Dinesha EP.
This tomorrow,
Yes, ma'am.
because it is a fresh matter.
Serial number 23.
Petitioner,
I
1 week
represent
time
the may be respondent.
granted. Or
They
the
have not
petitioner not contact.
They have not complied this honorable court order.
23.
Contact ಇಲ್ಲ ಸ್ವಾಮಿ petitioner 1 week time
Not the problem, no
Correct.
1 week.
Retire-
Let me see the cost.
ರಿಟೈರ್ಮೆಂಟ್ ಫೈಲ್ ಮಾಡ್ತೀವಿ. No for retirement.
Want to file it. Whatever you file, that the
1
court
week
has
time
to
may be
pass.
granted.
Your client can't have an interim order and sleep on that. This court has passed an interim order on 21/3/2025. As per the orders passed by this court, so interim order is not complied with. Hence, the interim order stands vacated. It's already stands vacated. You are at liberty to execute the same. Why are you mentioning it again?
The trial court, there is
I said you can take this order and show.
any date may be
A
fixed.
long
this-
date for this.
Any date may be fixed.
Date, it is 25 matter, no urgency to hear it now itself. Yes, yes.
Passed over this one. Serial number 10.
It's passed over. Yes,
This one
use
serial
some
number-
date, 15th or 16th.
15.
Yes.
File చేసుకుని. నిమిషం date కొడుతున్నారు.
Court officer serial number 21st of list 3 though. Date ಹೇಳ್ತೀರಾ?
ಯಾವುದು?
Cost list serial number 21.
21 in which number, ma'am?
3.
This 3 November, in the month of November.
ಹೌದಾ?
That is November 10/11. Serial number
23 input.
ಇದು 10/11
Madam?
ಕೊಡಿ.